Good morning or good afternoon all. This hearing is in the matter of CFI 009-2023 and is being held by way of video conference before Justice Sir Jeremy Cooke, with a sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Holman Fenwick Willen, lead counsel is Mr. Sharif Shipshi KC. The defendants are represented by Jones Day and lead counsel is Mr. Tom Montague Smith KC. Thank you, Your Honour.
Thank you very much. I've received bits and pieces in emails, none of which have I absorbed as yet because I've only just picked them up.
Very good.
You tell me where you want to go.
Well, I'm very grateful to my learned friends, and I think we've made good progress overnight in terms of narrowing the issues. So I think it was a wise decision not to have your lordship pre-reading overnight. I'm also very grateful to my learned friend for circulating a draft order. We have commented on their draft order, but only sent it back to them shortly before the hearing. But I'm grateful to my learned friend because I understand that nearly everything that we've changed is agreed. And I was hoping that it might be useful for me just to take you through the order that we have agreed. And I can just identify a couple of minor outstanding points, which we're going to go away and just check on this morning with a view to agreeing it all by the end of the day. So yes. Your lordship may have received a markup from us. So Mr. Montague Smith sent over his order and then we sent up a markup version of theirs.
Yes.
Just working through that, obviously paragraph 1 just essentially updates the previous orders to take account of this order. On paragraph 2, he had proposed 2 further CMCs. Now, actually, for 2025, we already have a CMC in the diary in that 3rd week of March, which was the point that we were just discussing when your lordship joined. So we are down at the moment on the 25th of March for a hearing. Ramadan runs actually really for the whole of March, and you probably heard what my learned friend said about his team members' availability during Ramadan. We're obviously very understanding of that. So we're just going to look at whether maybe a date in late April could be accommodated, but it's obviously dependent on your lordship's diary as well. That's probably the trickiest factor.
Yes, this is March, April next year, so we're looking at a point where hopefully disclosure is, if not complete, at least very much nearing completion. Is that right?
That's right. And
I'm trying to think of the the waypoints where it's sensible to have the hearing in the light of progress or non-progress.
Yes, and what we've proposed in light of that, what we've proposed is before that hearing, maybe 2 weeks before, the parties will file progress reports on their disclosure exercises, which will cover all of the material work streams that we've addressed your lordship on. And so you can evaluate as to whether or not we are all on track, and there will be sufficient time to push us if we're not.
So you're thinking April?
Yes, we're thinking perhaps towards the later end of April, if that suits your lordship.
Easter is 18th to the 20th of April.
That's correct.
The 25th would be doable from my point of view.
That works for me. I'll just check with my team.
I think that works for us as well. Thank you. Thank you, my lord. It probably makes sense then to release your lordship's diary for the 25th of March and the 20th of June, where we currently have listings.
Yeah. 25th of March, and what's the other date you've got? 20. Oh yes, there it is.
20th of June, I think.
20th of June, yeah. Yeah.
My lord, there is something to be said for a hearing in the second half of 2025
Yeah.
after the disclosure milestone, because often issues arise in terms of what's been given.
Well, we may or may not be into arguments about foreign assistance and so on and so forth, but I think it's a little difficult to plan for that because we don't know what sort of length hearing will be involved.
I agree with that, but if your lordship could perhaps put, I mean, again, it's dependent on your lordship's diary, but is it possible to have a hearing maybe in July 2025?
Yes.
Perhaps in later July 25, that gives the parties a period to take into account what they've got in disclosure and then to raise the issues.
I think the available week, that week would be the week of the 7th. I could do, as matters stand, anything in the week of the 7th, preferably earlier in the week rather than later. Hold on. Yes. How does that
works? That works for me. I'm just checking with my team again.
That is only, what, 10 weeks or so after the CMC that your lordship's just ordered. I mean,
that's true.
If that's your view, my lord, then obviously we'll come and talk to you about what's going on. It seems to us that there is likely to be an application of some sort anyway. But I'm told that July can cause difficulties. I've certainly got a trial in July, but I mean, I'm sure we can accommodate the hearing if your lordship thinks it's necessary. I'd understood your lordship's view to be, let's have one in 2025, one in 2026. That should be sufficient if people want.
Well, maybe later in the year is a better bet in 2025. Is it? Is that what you're suggesting, Mr. Montague-Smith, that we look in the autumn?
We can. We're in your hands, my lord, as to what you think is useful. We'd understood one a year would be fine, but because there are likely to be applications of one sort or another. But if your lordship wants another hearing, then I'm sure we can accommodate. But later in the year would make more sense. I mean, of course, issues can come up, and we can plan for that. That's absolutely fine. But if I can ask that be sort of later in the year, maybe pushed back towards November end, that might be better.
Can I suggest on that front that the key point is that once disclosure has taken place, obviously the vast majority of documents will not be covered by the MLA and ought to be given by the disclosure milestone. And once we have the defendant's disclosure, we will see whether there are gaps and unsatisfactory areas. And in the usual way, a party would expect to come back to court at that point to raise any concerns about gaps. And that needs to be done fairly swiftly. We need a period to review disclosure, but it needs to be done fairly swiftly after the disclosure milestone. So, I mean, if it's going to be, I can understand that July might be too tight, and if my learned friend's got other commitments, but my suggestion would be early September.
I mean, for our part, and I mean, I don't want to be difficult about this, but for our side, I think if there are to be allegations that there's unsatisfactory disclosure, those ought to be on an application, and the court will list it. But I mean, September, frankly, my diary next year is not great, so I'm not sure I'm necessarily the answer to the question of listing. Late September is not good either. I mean, I'm fairly clear I'm fairly clear in November, but again, we're in your lordship's hands. If you want to list something now, by all means. But I wouldn't do it on the basis that we're going to use that date to hear my learned friend's complaints about our disclosure. If there are those sorts of complaints, he should apply, so that we can see the detail sometime before the skeleton argument arrives.
Yes. Well, I'm thinking that we ought to be looking at putting something in the diary for a CMC, whether or not it's a matter for disclosure argument or not, but simply at a sensible interval after the April one, sometime in the autumn. As I say, if it's not going to be used, that's fine. There's no difficulty about it. Just take it out the die. At this stage, I would be thinking of let's just see.
If it helps, my lord, the idea was to have the next one in May 2026.
Yes.
So sort of a midpoint between the two might make some sort
exactly.
of sense.
Well, I was looking at October, November sometime, but trying to work out what would make sense. And
yeah, sorry, my lord, just on that, I mean, your lordship will know from these sorts of matters the issues that arise up after disclosure has been given.
yeah,
And if your lordship is with me and there are gaps, then my learned friend will need time to rectify them. And what we don't want to find ourselves in is the position we are again here, which is they say, well, it's now too late. The witness statements are fast approaching. We've made our application for MLA, so there's not time to rectify those gaps. So that is why we envisaged having a hearing fairly swiftly after the disclosure milestone. And I understand we'll need to identify any shortcomings if there are such shortcomings. But that does need to happen quite swiftly so that it can then it can be rectified and form part of the MLA if need be.
But my learned friend can make an application, my lord.
well, I'm going to put something in the diary for the 17th of July, unless that's objectionable to either party. As I say, it can always be taken out the diary if it's unnecessary, and if indeed, we've already had to grapple in a serious application with disclosure or anything else. As I say, it's no good, I think, trying to fix a hearing specifically for an anticipated dispute, whether it's about mutual legal assistance or disclosure, because the length of such a hearing would be unknown. So I'm just putting in a CMC on the basis that we're looking at 2 to 3 hours max, and if necessary, one can achieve that early in the morning before other commitments.
Yes, my lord. If that's the basis for it, that's fine. I think your lordship and I have a date the following week in a trial starting on the 20th. Maybe I may be wrong. Starting on the 21st of July. So a really heavy application. Well, maybe it's not in your lordship's diary. Maybe it's.
Yeah, it is. No.
Oh, it is.
Forbes,
well, there we are.
Forbes and Kidd.
Correct. Yes. So I mean, it may be a heavy hearing for me.
Is that really going to fight? Right. Okay. Pass on.
Interesting. The answer is I don't know, but there we are. I mean, assuming that it does, a heavy hearing in that week isn't going to suit me. But I'm sure we can accommodate a short CMC if that is what it's for. That doesn't sound like my learned friend thinks that is what it's for, though.
Well, I think we don't know. Your lordship's made the point, so we'll see where we are. But if the time can be usefully used, we will use it. If it can be vacated, so be it. Yeah.
All right. So we've got 25th of April, 17th of July. We'll leave everything else open until the following year. And currently, you're thinking what?
1st of May 2026, which is fine.
First of May. Yeah. Yeah, that's okay.
Very good.
Now, can we then go on to the hearing date? I've had further and better thoughts, noticing what I've got immediately following, and I wondered, in fact, if we could begin the 4-week hearing in the first week of September, but perhaps in the middle of that week. Would that create problems for anybody?
Not on our side, my lord, no. So that would be what around? Sorry, let me just.
2nd of September, for example. So we get 3 days in that week.
I'm being told that's fine on the defendant's side, my lord.
Well, let's do that then. The reason is I've got things immediately following that I haven't quite picked up on it when I was talking dates before, and I need to get back to this country and read in and so on and so forth.
Thank you, my lord. Shall we shuffle back the other dates then by the equivalent amount of days?
2025 or 2026? 2026.
I think that, in fact, at paragraph.
There's a typo. I think the trial date's in the wrong year, so that needs to be fixed as well.
Oh, well, it's only 3 days. Will it make much difference on everything else? You've doubtless gone for Mondays, have you? Basically.
Yes. I don't think it does make much difference on anything else. It may be that skeleton arguments can be moved back by a couple of days equivalent, but everything else I think can probably remain as it is.
Yeah.
Very good, my lord.
Seems to be sensible. All right, so we'll say beginning on the 2nd of September.
Thank you, my lord. And then the only other issue between us, which my learned friend was taking instructions on, was the date for trial bundles. And simply because the intervening period is the summer, we're hopeful that we can shuffle those back by a week. That was our proposal. The 27th. That's
fine. That's agreed, my lord. So
that's agreed.
So what? Which paragraph is that?
20.
20. Right. I think it's 19 on. Well, it depends if you reinstated paragraph 2. Depends which version you're working on, but I think it's 19 of the version that you were looking at. So that date of the 3rd of August is changed back to the 27th of July.
Okay. Yeah. Fine.
I
should say that I will come to Dubai for the hearing, and I will want a hard copy bundle.
Yes, of course. That's fine. I mean, I nearer the time, my lord, will need to discuss exactly what you want, and indeed there'll need to be core bundles, etc. as well.
Yeah, indeed so. Yeah.
No, my lord, sorry, there's one other date. I think just in light of this hearing on the 25th of April, in paragraph 3, the progress report on disclosure should probably now be the 11th of April. So that's 2 weeks before the hearing, so that your lordship has up-to-date information. Sorry, the 11th of April is, sorry, let me just check that. Yes, that's a Friday. That should work.
Yeah.
My lord, shall we, in light of this discussion, shall we just update this order, and we'll send it to my learned friends during the course of the hearing, and just get it agreed and send it back to you by the end of the hearing?
Excellent. Yes, please. Thank you very much.
Very good. Can I just mention one other? Hopefully, good news that we've, I think, crossed the custodian point off the list as well. So that was something that was agreed overnight. And can I just draw your attention to that? So this is paragraph 25 and 26 of the order you were looking at.
Yes.
So we've agreed to add Mr. Kerman as a custodian. Your lordship mentioned yesterday that there'd been a letter we'd written, and we'd received back a letter from Al Tamimi. I don't know if your lordship recalled that. And the essence of their position is that insofar as there are documents, they would already be in the possession of the company and therefore the liquidator. And essentially they had nothing more to give. We've added Mr. Kerman on the basis that we will search the documents in our current possession. But there's no expectation or requirement that we start proceedings against Mr. Kerman for delivery up of material, or that we enter some sort of dispute with Al Tamimi. So we are essentially taking what they've said as read on that front. And then there's been an agreement on the 5th defendant's custodian, Mr. Bookshi, about the date ranges. So, and I'm very grateful to my learned friends for agreeing that.
Okay. Does that leave outstanding all the list of questions that were raised in the draft order that Mr. Montague Smith provided, or his team provided, before the hearing?
That's right. So there's I think 2 areas that are left. One is the keywords, and the other is those information requests about disclosure. I wanted to address you very briefly on Mr. Gribby, but that should not take very long at all. It was just really a couple of points to note.
All right.
But I'll do that. If I may, I'll do that last. So, unless your lordship had a different view, I was going to propose that keywords are the next item, and Mr. Sampson is going to address you on that.
Right, and I take it then that this is to be at, quote, a very high level. Is that right?
That is our expectation.
Well, Well, we're very happy to do it that way. That there are the information. I mean, I was hoping we could dispense with the rather shorter points first. Not that I'm hoping for a longer discussion about search terms, but we're in your lordship's hands, and I will turn the camera over to Mr. Conte
if there are quick wins, low-hanging fruit, whatever the current expression is. Let's go for those.
Well, it's really the information requests in my order, of which there were 4. Really, what is left is 2.5, and then there is the greedy point that my learned friend was raising. But I mean, I don't want to be difficult, but I just thought it might be helpful.
Yeah, well, let's get those out of the way.
Very grateful, my lord. So the order that we are seeking, you will find in our draft, paragraph 33, and there are essentially 4 parts to it. The first of these is in relation to the Alpen Saracen, the Alpen side employees, if I can put it like this, of BSA. And your lordship will know that a number of those employees had effectively dual employment with Alpen and then with Bank Sarasin-Alpen. And when it came to issuing emails, communications, very often they used their Alpen side addresses. My own friends referred to the letter that Al-Tamimi has sent from Alpen, and also saying that the individual employees have agreed with the terms of the letter. That letter is at page 6776 of the bundle. And you will see what is said here. It's really the final paragraph of this that is important.
Sorry, I'm not there yet.
I'm so sorry.
Here there.
So this is a letter from Al-Tamimi, sent on behalf of Saracen. But if you, sorry, I do apologise. Sent on behalf of Alpen Capital ME Limited. You see that in the 3rd paragraph down. But if you look at the last paragraph, you'll see what's said in relation to the individuals, including Mr. Walia, who is obviously very senior in the Alpen setup. And the relevant passage I was going to take you to was the final one on page 6776.
Yeah.
And this is pretty much all we are told. Oh, sorry, the last 2. Our client's instructions are that to the extent its personnel were seconded to and or officers of Bank Sarasin-Alpen BSA, they provided any documents belonging to BSA to Mr. Shahab Haider, the original liquidator, in accordance with the applicable legislation. Any documents created or received by such individuals in the course of their secondment or directorship should therefore be in the possession, custody or control of your clients. And then says there's speculation and so forth, and just say, to the extent that we have anything, we've given it over. It is extremely high level, and so it is impossible to tell, for example, whether whether emails have been handed over or whether the documents referred to are client documents or what it is. And the particular concern is that no attempt may have been made to identify Alpen emails, ostensibly Alpen emails, but which were conducting BSA business. And we have had nothing from the claimants to tell us what they have in fact received. And so what we want to know is, what are these documents that were handed over to them from Alpen and from these individuals? What have they got? Because it's only then that we can assess whether or not this is a reasonable response, or whether actually the liquidator ought to be doing a little bit more to get what we say are the claimant's documents. So we have asked a variety of questions, and those are the ones that appear at page 5281 of the bundle in this 33.1 of the draft order.
But when I looked at the whole of this, request, all of paragraph 33, it's all about what the liquidator's actually got.
Yes.
I mean, in reality, what you're asking for, and probably all that in practice you could possibly get, is a list of what the liquidator has, isn't it?
Yes, but from that may well be illuminating, and that is what we've asked
I
for.
understand. No, I understand, but
Yeah.
I'm just exploring how far this can go. I mean, the idea that the liquidator now is going to start proceedings under Insolvency Act to try and recover documents of how many years old is, well, I should have thought a little fanciful, really.
Well, I think the way we have seen it, my lord, is that these are the claimant's documents, and there are points to be made about whether or not they have done a sufficient job in gathering in their documents. These are obviously relevant, we would suggest, and so, for example, your lordship's ordered custodians from the defendants for non-exec directors from 10 years ago, and we've made inquiries and we've taken real steps to go and get those documents. And my own friend talks about points to be made about gaps in our disclosure and more that can be done. And there may be documents that we will make, there may be points that we will have about this, but until we know what's out there and what they have, we can't know whether those points arise, whether we might be in a position to make applications if that is an appropriate course.
I don't want to stop you, Mr. Montague Smith, but I'm with you to the extent that the liquidator ought to say what he's got.
Yes.
And I'm just looking for a shortcut, in a sense, to answering all the questions.
Well, for the purposes of today, that's what we're asking for, and we're asking for detailed questions, some detailed questions really about what they've got. I mean, the central part of it is 33.13.
Yeah, well, that's what I was thinking.
Yes.
That basically, the liquidator, particularly the new liquidator, can say what, in fact, she has in her possession, what she's got. How much it's necessary to go trawl through when and where it was all provided and so on and so forth seems to me to be possibly not very helpful at this stage. If there are obvious gaps, then she can be asked.
I think
have you tried to do this, and what do your records show? What's the previous liquidator do, and so on and so forth.
Quite,
but the first step is simply tell us what you've got, isn't it? Give us a list of what that is.
Well, we've asked that question, and we hope not to have to trouble the court with it, but it hasn't been answered.
Right.
So here we are. What's important to us is that we're told what there is in a way which allows us to assess the adequacy of what's been provided, and therefore allows us to assess whether or not there is further steps that we might need to take.
If I was to make an order saying that the liquidator should provide a comprehensive list of the materials that had been obtained, bearing in mind the questions raised in paragraphs 33.1, 33.2, etc., would that meet the point, at least initially?
I think so, yes, my lord.
Are you handling this, Mr. Sampson, or is Mr. Shivji?
No, I'm dealing with this point.
Would you have any problems with that?
Well, Your Honour, I do object to that. First of all, the liquidator has been very clear about what documents or repositories are in her possession and what is being searched. And the defendants know that. They know that we're searching the servers and hard drives that were handed over to the previous liquidator, and we're also looking at the previous liquidator's investigative files. Now, the genesis of the correspondence on this point is actually the defendant's request that started life as a request that we make an application for the production of documents. And now it's morphed into this request for information about what the liquidator has. But we have done what we could reasonably do, which is to write to Alpen and to ask them to produce to search for and produce any documents. And that letter is at 4469 in the bundle. And the request, the specific request, is actually at 4471. In paragraph 11, Your Honour.
Let me just quick flip through this letter.
Of course.
Yeah, and what was the response to that? Was that the response I've just read?
That was the response that you've just read, the letter from Al Tamimi. And the request as formulated in paragraph 11 is what the defendants asked us to ask of Alpen and the people associated with Alpen. So we have done precisely what they asked us to do, and Your Honour has seen the response. And that is the current state of play. Now, if we look at the order for information that my learned friend seeks, and it's a very lengthy composite set of questions with sort of 7 points in it. But my learned friend said that the key point is 33.1 Roman 3, which is a detailed list of the Alpen documents so provided. But Your Honour, that's just a request for early disclosure, because disclosure is given by list and we then produce the documents in the normal way. And the date for that has been moved back to the 30th of June. So my learned friend is just trying to get early disclosure from the liquidator.
Yeah, well, I appreciate this is all I was thinking of ordering was a list of documents. I don't really see why that shouldn't be done earlier rather than later. Disclosure is an ongoing exercise, and it's plainly going to be ongoing for some time, but subject to an adequate time limit. I don't see why that list shouldn't be provided.
Well, the second point, and this is why we say an order is with a specific timetable is difficult, is because we've got to liaise with Mr. Hyder about this, and Your Honour has seen, and we're going to come on to this in relation to the electronic data queries, but Your Honour has seen from Mr. Baganza's evidence that the liquidator and HFW have been pursuing Mr. Hyder for information. He's been cooperative, but of course there have been difficulties on his side, and it's taken a long time to get the information. But we have got the information in the end. So it's not that the liquidator is uncooperative and doesn't want to provide information about the documents that she holds, but making her subject to an order and requiring her to do this in short order is going to be difficult, because it requires the input of the liquidator. So,
Mr. Sampson, I'm going to make an order. It's just a question of you telling me what might be an appropriate time limit, given the difficulties with Mr. Hyder's family bereavements and the like.
Well, Your Honour,
you can make a suggestion to me, and subject to Mr. Montague Smith having some particular problem with it, that's perfectly workable.
Well, Your Honour, it's difficult for me to say, because I obviously don't know what Mr. Hyder's availability is, because he's no longer my client. But if we said by the 20th of December, so it's done before Christmas.
Yeah, that's fine. Fine by me.
Fine by me, my lord.
Right, 20th of December then, Mr. Sampson. It will be a detailed list of the ACME documents provided, bearing in mind the request for information contained in whichever the relevant paragraphs are, 33.1, 33.2. Is that it? Yes, 33.1, 33.2. Is that right, Mr. Montague Smith?
I'm told it's Mr. Kerman is not, in fact, an ACME employee, so it may just need to add him, if I can put it like that. He's from the ACME side of the BSA relationship.
A detailed list of the ACME documents and those provided by Mr. Kerman.
Thank you.
Your Honour, detailed is a bit concerning, because ultimately all the documents that the liquidator has have come from ACME in one way or another because they provided the servers and the hard drive. So, I mean, if my learner friend is going to come back and say that we have to list out every single document individually,
No.
then that's
No, I'm
going
sure
to be impossible.
He doesn't want a list of every single individual document, does he? What he wants to know is essentially the type of documents that you've received, what you have. I mean, if you like, we can simply say a list of the ACME documents and those provided by Mr. Kerman, bearing in mind or taking into account the request made in paragraph 33.
So perhaps I'd suggest then that we pick up the wording in B Roman 1, which is refers to categories of documents, Your Honour.
Well, it'd be 1.
My Lord, I would suggest that it's pretty clear what your Lordship wants. It's pretty clear what I want. My learned friend has an understanding, I'm sure, of what it is we're trying to achieve with this exercise. And my concern is that by drafting some sort of detailed statute, which they're then going to respond to, we're not going to get the information that we require. I think everybody knows what your Lordship's ordering. We need a list.
You need a list. I mean, it's a list of documents of the kind that used to be produced in litigation years ago, but it didn't necessarily descend to an email of this date, a letter of that date, and so on. But it did descend to sufficient particularity to know what types of correspondence and so on and so forth had been given. So, it would have a date range to it, for example, and so on. I mean, what's required, Mr. Sampson.
That's all very clear. I'm very grateful. So I think if we just leave it as a list of the ACME documents, we can work with that.
Okay, well, if there's a problem on the drafting of that, come back to me, but that's something that can be built into the draft that is currently being put together by the claimants.
Grateful.
Thank you, my Lord.
By the end of today, we'll have a form of words, I hope. We'll
do our best. Thank you. Thank you, my Lord. So the second issue, I think, has gone in that that was about a data room. I think that Mr. Sampson had mentioned a data room at the last hearing.
Yes.
There's a bit of confusion about what that is.
It's the same as the investigative documents, isn't it?
Yes.
Even I picked that up, Mr. Montague-Smith.
Well, as I said, the rest of us mere mortals sometimes misunderstand things, my Lord, and it may be our fault or it may not be. But I won't burden you with that dry debate. As long as the documents are going to be searched, and I think that's been said, then that's all fine. So we can put a line through 33.2, and then 33.3. It arises because there was at least, or there may still be, an issue about the integrity of the claimant's data, and this arises because the claimant solicitors had previously said that they had identified gaps in the claimant's documents. We had understood at the September CMC, you may recall there was an application at that stage for the liquidator to provide a witness statement. And there was a bit of argument about that, and I suggested that as long as she put her name to it, didn't much matter, but we wanted to know the information, and we'd understood that was that the liquidator was happy to provide that, but ultimately we say she has not provided a comprehensive picture. What happened is we received some information on Sunday, which you'll find at page 6817. And it's at page 6818. Further information to be provided by the liquidator. And you'll see this is the account at paragraph 8 that we have, and it goes down to paragraph 9 as well. There are some answers to a number of the questions, and then down at paragraph F, it is said, neither the current nor former liquidator has identified any gaps in BSA's data other than in relation to the finance folder, which was subsequently resolved. We don't know how it was resolved, what the gaps were. And then at paragraph 9, what is said is the liquidator is awaiting information in connection with your queries about the finance folder. We are continuing to seek this information and will provide you with a further update as soon as we are in a position to do so. So ultimately, where we understand the position is that there may have been a problem with the finance folder. Don't know what the problem was. It has been resolved, but we don't know how it was resolved, and that further information is awaited in relation to this. So in light of those responses, and the ones I haven't shown you because I don't want to burden you with all the detail of it, some of the queries that we have raised have fallen away, and so we wouldn't press all of the points that we were asking for in order 33.3. If your lordship has that, it's on page 10 of the draft order. But what we would continue to press would be D, a statement of when the documents pertaining to the purportedly deleted finance folder came into the second claimant's possession. E, a detailed explanation of how the finance folder documents came into claimant's possession. And then J and K, insofar as they relate to the finance folders. I mean, these are ultimately the most important bits. A statement of any gaps in BSA's data in the finance folders that has been identified. And K, a detailed explanation as to any investigations. And we would add or resolution that the second claimant has conducted into why any such gaps exist.
I made a note alongside this order. What is this really all about? And what is the finance folder, and what sort of material is contained in it, and how is that likely to relate to any issue in the litigation?
Well, I don't know is the answer. These are documents that are held by the liquidators.
Yes.
They've said that there is a significant gap at one stage, or a gap, we were told. We're now told that a gap was identified and resolved, and we're simply asking what was the gap and how was it resolved?
Well, I understand that, but I just wonder how this advances anybody very much. Perhaps Mr. Sampson can help me what the finance folder is, what it contains, and how it may be relevant to anything. I think Mr. Sampson is as ignorant as you are, Mr. Montague.
We would expect it to be about the valuation, or relevant to the valuation of business as a whole at that period. Okay. That's what we would expect. Yeah. We simply don't know, but because ultimately what's being said is they've identified this data, and then they found there was a big hole in it, and it was an identifiable hole. And your lordship's asking me, well, what's in it? What's in the hole, and how do I know that it's relevant?
It's apparently been resolved, but
well, I know. And
why don't I simply order that a letter be written by way of explanation in relation to the finance folder, and then we'll take it from there.
Yeah, that's all we're really asking for, and all we want is a date for that. Now, I think what my learned friend's going to say is, well, we've been asking Mr. Hayder, and he's got family problems, and he's taken a very long time to respond to all our letters, so we don't know. But if we could have something by the end of the year, I think that this would be a way of knocking it on the head.
Well, let's say the same date again, shall we, Mr. Sampson? Are you happy with that?
I think that's very sensible, Your Honour.
And you can explore whatever is what is the finance folder, what it's about, and whether it actually has any relevance at all. I'm self-evident if it has valuation to the business and that sort of thing, it may be of importance. But finance is such a wide subject; it could cover anything at all. All right. Well, that's that again. That's go in the draft order, please.
Very good, thank you. And then the only other issue was 33.4 in relation to hard copy document repositories. And much of this has been resolved more recently. But just to show you very briefly one of the things that was said, the letter that we are looking at, if we go to page 6819 and look at paragraph 10, this is part of the explanation that came on Sunday. In relation to your question regarding that, this is about the boxes, the hard copy boxes. The numbers given in our 5th of November letter, these are explained as follows. The 10th file held by Mr. Hayder was a ledger of Altamimi invoices. It has not been misplaced. 202 boxes are stored with Sibco. No additional boxes exist that have been misplaced. 212 is the total number of hard copy boxes, including the 10 held by Mr. Hayder.
Yeah.
So there's a reference to the 10th file, but apparently he's got 10 boxes. So there's a bit of confusion there. And ultimately, what we don't understand is whether or not Mr. Hayder still has these 10 boxes, whether or not, in fact, they're 10 files, what he has, what he's going to give them, or whether he's going to provide them at all.
Could I just suggest that my learned friend looks at paragraph 13, which I think answers that point?
Right. So were there 10 boxes then? Maybe my learned friend just answer the question that we're worried about. Were there 10 boxes or 10 files? I mean, ultimately, what was there?
Well, my understanding is that they are 10 boxes. 10 boxes. I confirm that they're 10 boxes. They were held by Mr. Hyder. I think they had been taken out of the 212. The 202 went to Sibco, 10 went to Mr. Hyder's offices. The 10 are now with HFW.
And so all 212 are now with HFW, and they're all going to be subject to a manual search.
The 10 are with HFW. The 200 and in paragraph 13, the second sentence explains HFW are arranging for the delivery of the Sibco boxes to our offices, with the aim of taking possession of them this week.
Yes. What's the reason? Yes.
And this is the hard copy review that was discussed yesterday.
Very good.
Yeah.
All right. Is there anything else? No. Well, that clears that up then. Yeah, understood. Very good. All right, and that includes the 10th file, presumably. But there we are. In which case, I don't think we need that document request, that information request at 33.4. You can put a line through that one as well.
Thank you.
Thank you, my lord. That is everything from our side in relation to that.
Right. Thank you.
Greeby and Antrik is all that is left on the ancillary list.
Greeby and what?
Asterisk, sorry. My learned friend's application in relation to orders that he wants you to make about Mr. Greeby and Mr. Antrik. Asterisk.
I think before, I'll defer to my leader if he wants to deal with that now, but I think we were going to, I think he said he would leave that to the end and that we were going to deal with keywords first.
I don't mind whichever order. If something's quick, let's deal with it. If it isn't, we'll move on.
I'd suggest you deal with keywords next, and we'll deal, as I said, we'll deal with Mr. Greeby at the end.
Okay, all right. Keywords next. So, Mr. Sampson, this is your pigeon.
My lord, we just need to make slight readjustment of the hearing room that we're in so that Mr. Conti can be on camera. It'll take me about 10 seconds.
Yes, fine.
Which one's mute? That one there.
I hope the parties have noticed that I now have an appropriate, proper background. Instead of the crooked pictures that you've been looking at in the past, I have managed, with some assistance, to put in the DIFC background.
Well, Your Honour, I'm sure that the DIFC people in the court registry are very pleased about your background, although I have to say I liked admiring the pictures.
Well, I thought it was more interesting, but there's a question of uniformity and propriety and so on and so forth. So here we are.
Even judges have to be on brand these days.
I'm afraid we do, yes. Yes, right. So
now
where are we going next?
I see Mr. Conte has taken his seat. So on the keywords, I'm pleased to say that following some discussions yesterday evening and the exchange of some documents, the issues have narrowed considerably. There are still issues, and we will have to, I think, go through them so that we can resolve them, Your Honour. But I'm hoping that we'll be able to take it relatively quickly.
Okay.
And so we won't take up too much of your time this morning.
On that point, I wonder whether if my learned friend thinks it's the way forward. D's keywords are quite short, and it might help if we address those first, and if I go first, because I think there'll be more debate when it comes to C's keywords.
Well,
which documents do I need for this? I received a whole lot of new stuff this morning that I haven't looked at, but I assume that that's the material I should now be engaging with, is it?
Yes, Your Honour. I was just
Yes.
about to explain what the materials are, and I was going to, in fact, propose that we start with the defendants. And because the claimants have responded to what we received last night, we've narrowed the issues even further. So I was going to explain to Your Honour where we are, and then make a very brief point on why there are certain things that we want. So Your Honour has received overnight 2 tables from the defendants which set out the position in relation to their custodians. I think those form part of the insert that was sent to you. I'm not sure if Your Honour has the documents separately or as a single PDF insert for the bundle.
Oh dear. Well, of course, I simply printed out what I was sent, which is in such small lettering that I'm having problems seeing it. So it'd be better to have it on screen so that I can zoom it in.
It was added to the bundle, so it may
You
be
know
that
where?
Yes, I have the page references.
Oh, right. Good.
If Your Honour also needs a section, I know Your Honour sometimes asks for that, then it will be...
If you give me a page number, I can locate that.
Well, let's start with D4 then, which is at page 7589 of the bundle.
Yes, fine. There's the zoom function. 140%. Yes, go on.
Right, so these are the points that remain an issue for D4's custodians, and the list is lengthy because my learned friend has split it out in relation to individual search queries for individual custodians, but actually a lot of these can be rolled up because it's the same point for many of them. But the position is that what's an issue today is items 1 to 4, and then there's a minor point on items 29 to 45. So really, there are just 2 points to make on this. And so on items 1 to 4, those are in relation to general searches for particular custodians. Your Honour will see that they relate to Elie Sassoon, Edmund Carton, and Stefan Astruc. So those are the individual defendants.
Yeah.
Those are the parties that the claimants accuse of having been in an unlawful conspiracy. And the proposal in C's counter proposal column, which is sort of in the middle of the sheet, is for all email communications to and from these parties and certain other parties. So in relation to Mr. Sassoon, it's all his correspondence to or from Mr. Astruc and to Mr. Carton. In relation to Mr. Carton, it's all emails to and from Mr. Sassoon. And in relation to Mr. Astruc, it's all correspondence to and from Mr. Sassoon. So in a case like this, where we allege a conspiracy, we say that a general search of the emails passing between the parties is quite important because they may have corresponded with one another about the conspiracy. I mean, I take the point, we were discussing this yesterday, that phone conversations are often very important, but we have seen evidence in the emails that they did refer to plans to relaunch the business, and Your Honour will be well familiar by now with the relaunch plan email that we've looked at several times. And so we say that there ought to be a careful general search, and our starting point on this was that there should be a manual search of the documents between those particular parties.
Date
But-
range.
I'm sorry, Your Honour.
Date range.
Well, the starting point was for the full date range of 2012 to 2016, but this is one of the areas of potential compromise. So we've offered up a date range of September 2013 to December 2014, which is really the period in which the scheme, as we allege, is being formulated and enacted. So we've limited it in that way. And then if we go to if we just move away from this document for a moment and go to 4929, and the reason for that is because Malone and Friends' schedule doesn't quite capture what the current proposal is. So if your honour has it at 4929, this is what the claimants had proposed as part of their recent counter proposals. And you'll all see that there are general searches, and we've covered for each of the custodians the communications to or from certain individuals. And in relation to Mr. Sassoon and Mr. Astruc for Carton, and then obviously shuffling them around depending on who the custodian is, the emails that are to be searched should mention first claimant or the fifth defendant, because those are the relevant entities involved in the scheme, as we allege. And so there's a sort of subject matter narrowing down of this general search. And there's also the proposed date range that I've just mentioned. So we say that all makes it proportionate and important for a reasonable search. And of course, if this is what the defendants do in relation to these three custodians, then when they perform the keyword searches, duplicate documents are going to be filtered out by the deduplication process. So it's not going to add to the review. It's going to make sure that it's comprehensive in relation to the three parties who are accused of having been in conspiracy with one another. So
now with a narrower date range than appears on this document, which is
yes, it is. That's a development. That's a development overnight.
Yes. Okay. Understood.
So that's the position on those items. And then the other items, I said it was so if we go back to 7589.
Items 29 to 45.
Yes. These are search terms for a variety of custodians, but they're all the custodians that are in that first group that we were looking at. So they're people who are either involved in the day-to-day running of BSA or on its board, or were executives in BJSS. So we say that they're people who had close involvement in the relevant businesses, and therefore we say they would have had close involvement in connection with the scheme. They were either the parties to the conspiracy on our case, or they were parties who would have had information about it or would have been discussing the strategic issues in the respective businesses. Now, the keywords themselves are all terms that relate to the transfer of business in various ways. So if you want to look at, for example, 29, item 29 in my Learned Friends schedule, that's a search term for Mr. Carton in relation to the transfer of assets under management or clients or business partners from BSA or to BJSSAM. And the proposal has narrowed down. So in the second to last column from the right, my learned friend proposes a limited date range, and he's taken out some of the search terms that are included in the string. And the only point that we take on this is that at the end, they've put in BJSSAM, but as Your Honour will have seen from other, from the skeleton, this was a general issue in relation to the searches. The defendants were proposing to take out certain acronyms that we know were used for the fifth defendant from contemporaneous documents. So if Your Honour looks at my skeleton argument, paragraph 70,
Yeah.
then we explain here what the variations are. and we quote the documentation in which those variations were found. So again, as I've said to you on previous occasions, our keywords are rooted in the documents, and what we've seen was actually the language that was used by custodians at the time. And so the point that we make is that the search shouldn't be limited to BJSSAM. It should capture all of the known acronyms, which would be BJSSAM asterisk, because sometimes it was referred to as BJSSAM-L, JSSAM asterisk for the same reason, SSAM asterisk for the same reason, and SAMME, which was also an acronym that was in use at the time. So all we're asking is for that BJSSAM term to be expanded somewhat to capture relevant references to D5. And that's the point that goes for items 29 through to 45.
Yes.
I suspect it's useful now to hear from Mr. Conte before we move on to the
Yes.
D5 terms.
Yes, Mr. Conte.
Thank you, my lord. Before I come to my learned friend's points, I just want to put where we are in context, if I may, just for a moment. So at the end of the hearing yesterday, your lordship indicated that he wished for the parties to go away and come to an agreement on keywords as soon as possible so that everyone could get on with the task of beginning their respective disclosure exercises. Now, the defendants overnight took that very, very seriously. So what they did is they worked very, very hard overnight to formulate a sensible proposal for the claimants in which they reduced the areas of dispute quite considerably to what they considered to be an absolute minimum, thus allowing the court to rule on a very limited number of disputes if necessary and make an order setting the search parameters the defendants will apply to their custodians' electronic documents. And you'll see from the responses that I'll have from my learned friend, I'm very confident that the court will be in a position to finalise the defendants' keywords today. Regrettably, for reasons that I'll come to when we get to it, the claimants have not taken the same approach overnight at all. And in fact, rather than being cooperative and progressing this process to a resolution as soon as possible, I'll take your lordship to some documents that show that actually what's happened overnight is they've muddied the waters. So in those circumstances, just as a headline point, I'm afraid there is, in my submission, not a real prospect the court will be able to finalise the claimant search parameters today, despite the indication that was given by your lordship yesterday. So if we just turn to my learned friend's points, they sent them out in an email earlier this morning, and we've been getting instructions while my learned friend has been making his submissions. And I'm instructed that, let me go back a step. What I actually like to do before addressing my learned friend's submissions is just explain the general approach the defendants took overnight. So let me make good the proposition that they took this seriously, they're trying to cooperate, and they want to get a resolution today. So 3 points. So first, the defendants, what they did overnight was apply a unilateral floor of 2,500 hits. So what that means is for all of the claimants' proposed searches that produced results of 2,000 hits or less, simply accepted. Made a pragmatic commercial decision, D4, made a pragmatic commercial decision to accept those hits, and D4 just accepted them. The second point is D4 restricted the objections based on disproportionality to only cases where it was disproportionality alone to anything over 2,800 hits. So there were objections in the table that you've been provided with where the hits were less than 2,800, but D4 made a practical commercial decision to say, well, if it's less than 2,800 and it's only disproportionality, we'll not take the point. And notably, what the defendants also decided to do was withdraw their objections to several of the claimants' proposed searches, where the disparity between the claimants' proposed searches and the defendants' proposed searches were over 1,000 hits. So you may have had the claimant suggest something that was 2,500, the defendant suggest something that was 1,400, didn't matter. They still conceded the point in the interest of getting this done today. So my learned friend referred something about how the tables that we produced were rather lengthy because they were 5 pages. Well, can I say there were tables attached to our skeleton and they contained 334 objections, and there were multiple pages. What the 5 pages that were submitted overnight contained were 45 objections. So we've got to put it in context that your lordship gave some very, very clear guidance about what the parties should be doing to be sensible overnight, and D4 has been sensible, and I'll come to D5, who have also been sensible. So we've got to put where we are right now in that context. So my learned
Mr.
friend
Conte, it may not be important, but I'm not sure I grasped your third point about a disparity in documents and what you'd conceded.
Oh, of course, sorry, my lord. Let me unpack that. So there've been a range of proposals and counter proposals over the time, and I don't want to bore your lordship with the detail, but it's basically been a process where one party has suggested keywords, the other side has suggested counter proposals, then gone back and forth. And there were particular results where the claimant's hits were much higher than the defendant's hits, and the gap between them was over 1,000 or around 1,000. And even though that was the gap, in the sense that the defendants would have been much better off arguing the point, because an argument I could have been making to your lordship today was, well, comparatively, the claimant's searches are disproportionate because the defendant's searches return such a lower level of hits. We haven't taken the point. And we haven't taken the point because what we had understood yesterday from your lordship was, it's time to be sensible, it's time to be reasonable, it's time to engage, and it's time to get on with it. And so the defendants took a commercial, pragmatic decision, and they just said, well, we won't object. And so that's where we are. And as I say, my learned friend referred to the long list of 5 pages, but it was 334 objections, and overnight it came down to 45. So what my learned friend did overnight is they sent an email and they set out their position and they conceded on some points. Today he's raised points about items 1 to 4. And again, defendants have been pragmatic. We've taken instructions during my learned friend's submissions, and I'm instructed that we agree with the proposal, provided it includes the date range and it includes the company names. And now turning to my learned friend's submission in relation to items 29 and 45, again, we've taken instructions, and again, the fourth defendant has been pragmatic and just simply agreed. Again, subject to date range and the other amendments that my learned friends proposed. But where that leaves us is what wasn't addressed in the email this morning, and what my learned friend hasn't canvassed, is his response to 19 and 20 on the list. It wasn't in the email, and my learned friend hasn't raised it. So I'd be grateful if you would.
19 and 20 on this list at page.
Yeah, so page 7590, items 19 and 20, which are 2 searches relating to Edmond Carton in relation to the movement of the business. One produces 3,392 hits without family, just the parent, and the other one produces nearly 3,000 hits without family, just the parent. The objection we took to those, because they were over our self-imposed floor, was that we say both of them are disproportionate, but from my reading, and apologies if I've got this wrong, it doesn't seem to be covered in the email from this morning from my learned friends instructing solicitors, and he hasn't covered it in his submissions.
Well, Your Honour, I'm sorry, that's an oversight in the email, and I've been making my submissions by reference to the email. If it assists, I'm perfectly happy not to pursue, to accept what my learned friend says here, which is that they object to the term, they don't want it in. Fine, we'll leave it out.
Okay, fine, good, thank you.
If I can move on to D5 then, because I think that deals, unless my learned friend thinks there's anything else outstanding in D4. No, then let's move on to D5. Your Honour, I'll show Your Honour what we did overnight when I get to the claimant's keyword searches. I'm not going to address what Mr. Conte said.
Well, he says he's been very reasonable, as people always do.
Well, he says that I've been very unreasonable.
Yes,
I'm
well, that's
surprised. I'm surprised by that submission.
I take these submissions as read. I don't need them to be said almost. I assume that each party thinks it's reasonable and the other's unreasonable.
Well, for
yes,
what it's worth,
on we go.
For what it's worth, I think the defendants have been very helpful overnight and very reasonable, but there we are. So on to D5, there is a single sheet at 7594.
7594, thank you.
And so these are the points that remain in relation to D5's custodians, and items 2 to 4, 8 and 12 can be removed from the searches. Item 5 can be removed in relation to Mr. Adnani. We've agreed all of that. So that leaves items 1, 6, 7, 9, 10, and 11. They all relate to Mr. Philip, and the claimant's position is maintained. And if we just look at what those are all about.
This is the one which both sides were searching for, Mr. Philip. Have I got that right?
Yes.
Because yeah.
Yes, and so these are terms that relate to the hiring exercise in relation to RMs and
Yes.
the movement of clients and the business, or the retention of it, or the transfer of it,
Yes.
or of clients or business or relationship managers. You know, it's the transfer scheme put in
Yes.
various ways. Now, the reason that the claimants maintain their position on this in relation to Mr. Philip qua D5 custodian is because, and I should just highlight that the objection to this is about the dates, because the defendants say that these events took place in 2014 and Mr. Philip joined D5 in March 2015, some months later. And so this set of terms is not relevant to what he was doing at D5. But we disagree with that. And the reason is that, as Your Honour has seen, I'm not going to turn it up, but the client onboarding report that was produced by by D4's audit group, but in respect of D5, was produced. In fact, perhaps it is helpful to go just to see the dates, actually. So that's at 3169 in the bundle. So, Your Honour, just as a reminder, this is a audit report produced by D4 in relation to client onboarding. We can see that from the top. There is a section called distribution, which tells you who received the document, and right at the bottom is Mr. Philip. His function was compliance officer. There is a time log at the bottom. The fieldwork began in February 2015. The report was issued in June 2015. And then if we actually go to page 3173, the report is signed by Mr. Philip. And Your Honour has been shown this document before. But in essence, and we get this from page 3170, the DFSA had performed a risk assessment in relation to D5 and raised actions in relation to the onboarding process. And so this was a report, and that's in the third paragraph on 3170. So this was a report into how D5 had obtained its clients. And so there was a discussion, there was an investigation into that in the first half of 2015, and a report produced. And because this was a report in response to the DFSA, there were action points so that the claimants understand that there would have been discussions with the DFSA after the report and the recommendations had been produced. And we would say that it's highly likely that there would have been internal discussions within D5 and within D4, since this is a document that emanates from D4, in relation to what happened in 2014, all going on throughout 2015. And it's not a stretch to imagine that that went on into 2016 as well, when the date range ends with the liquidation of the first claimant. So we say that the defendants are wrong to suggest that these terms are irrelevant to the period in which Mr. Philip was at D5. We can see from this document that he actually had his hands around these issues, and therefore is highly likely to have relevant documents that speak to how the clients came from BSA to D5. And so we say that these are material, reasonable, and proportionate searches for D5 to carry out.
Sorry, Mr. Sampson, I haven't got the difference between you on the date range.
Well, there's no difference in terms of what date range should be searched. The point is, the point about the date goes to relevance. So the defendants say these are events that took place in 2014, and Mr. Philip was only at D5 from March 2015. And so yes, that's the relevance of the date. But in terms of the search range that we have proposed, there's no point taken in relation to that. And that search range
I'm
is
being very dense here. I still haven't got. Let's go back to 7594, is it? And see the ambit of what's being asked for. So if we look at, they're all the same, are they? So we can look at
Yes.
item 1.
Yes.
Oh, right. I'm sorry, I have been very dense here, Mr. Sampson. It's the whole nature of the search that is in issue, not simply a question of date by reference to the time he joined.
Yes, I'm sorry, Your Honor, I probably didn't explain that very clearly. Yes, they object to these on the grounds that they're simply irrelevant because they don't relate to the time when Mr. Philip was there. And I've just been explaining by reference to the audit report that, in fact, they do relate
because he was compliance officer, he got involved in exploring all these matters, is what you say. Yes, got it. All right.
So that's what we say.
Right, Mr. Conte, are you going to deal with that?
Yes, thank you, my lord. So some points in relation to this. First of all, I mean, we do have to note in relation to disproportionality, and we'll just work with the first entry, 1,716, but actually, if you go down the list, they range up to 3,288. That's the ninth entry. So we are talking about hits that are quite large. So on disproportionality, my learned friend has to answer why these searches should be performed when there's not just a disproportionality objection, but also relevance. In terms of relevance, there's a point to be made here that what this is interested in is the audit and discussion around the audit, and there is a search string that we've agreed to. It's not in the list that we've sent to you overnight, just simply because in order to remove the agreed terms and clear the terrain, we didn't send the agreed terms. But there is a search that was agreed overnight that includes the word audit, and there's also a search that was agreed to formally that agreed to a search of the actual file number for the audit report that appears in the document. And so those two terms are agreed. And so it is, we say, very likely that when you apply those search terms, they will catch the relevant discussions or documents evidencing the relevant discussions, if any. So that's my first point on relevance. My second point on relevance is this. Some of the searches relating to the transfer thesis are below the unilateral cap. So I explained to your lordship a little earlier about how in order to clear the terrain and be reasonable, the defendants just applied the unilateral cap. In the case of D5, that unilateral, sorry, not cap, floor, that unilateral floor was 1,000 hits. So again, all of the claimants proposed searches that were 1,000 hits or less, D5 just accepted, and you'll see from the table, D5 only took disproportionality objections where they were solely disproportionality to results over 10,000 hits. And just for the metrics, that reduced the table from 66 objections to 12, and that's why the court is in a position now to finally determine these search terms out and out. So taking that as the background, some of the searches relating to the transfer thesis, which is what these searches relate to, were searches that fell below that self-imposed floor. And so therefore we say those searches are likely to catch the discussions. And from what I can tell, or what my instructors tell me, there's about 5 searches that we agreed that actually cover the same terrain. Third point is, to the extent that it's relevant, some of the communications will also have been sent to other D5 custodians or even other custodians generally, and so there will be an overlap. So Mr. Phillip may very well have been copied in or received any of those emails. So again, the relevant discussions will be caught just simply via another custodian. And my next point's about the DFSA report that my learned friend referred to. So that report was about onboarding generally. So it effectively focused in things, for example, like KYC, was the file complete, just general points, mechanical points, if I can put it that way. It was just not about how D5 acquired BSA clients. So I think my learned friend made a submission to that effect, and that's, in my submission, factually incorrect. My fifth point is that report, the DFSA report, is actually dated 2014. It's actually dated October 2014. I won't ask you to turn it up. And so its relevance, I think, is much more limited than what my learned friend says it is. But ultimately, I mean, what we say is these relevance objections are quite powerful on their own, but combined with the disproportionality objections, they're just not searches that we say are appropriate. And so one last point is the field work for the audit finished in February 2015, which again was before Mr. Phillip joined D5. And if you need a reference, my lord, it's 3169 of the bundle.
Your Honour, I think there are some points there that Mr. Conte said I should come back on. I mean, the first is the proportionality point, and Mr. Conte is sort of driven by the hit numbers here. I mean, they don't really tell the full story because these show hits in the documents, but of course they don't tell you how many documents actually produced by the searches. That number will be lower. In particular, obviously, these are overlapping searches, so there will be duplication between the search terms. We know that, and we accept that, and that means that the overall number of documents produced by them is going to be lesser than just adding up the number of hits that we have here. And that's related to what my learned friend was just saying, which is that other searches will capture communications where Mr. Phillip will have been copied in. Well, that's right. And so any documents produced by these searches will sort of be deduplicated by that reason. But of course, as I've shown you, Mr. Phillip signed the report. He was involved in compliance matters. So the fact that the fieldwork happened beforehand doesn't really meet the point, because this was a report that was then issued in June when Mr. Phillip was in situ. He signed it, and there were recommendations which had to be acted upon. So this is all ongoing while Mr. Phillip is there. And then the final point, if we look at 3171, my learned friend said that this is nothing to do with the prospecting and onboarding of clients in the way that we say it is, but it is, because if Your Honour looks at 3171, there's the bold heading: client interaction is initiated only once the formal relationship has been opened, and the first paragraph underneath that talks about the extent of client interaction in the sense of advisory activities permitted during the prospecting and onboarding phase would have to be addressed in a recommended formal directive addressing the prospecting process. So this report is looking at the prospecting process, and that's what at the heart of the claimant's complaints in this case, that there was improper client solicitation, i.e. prospecting. So we say this is relevant and proportionate.
Yes.
And there was one further point I had, which is that Mr. Conte talked about the fact that an audit search has been agreed. I mean, that will cover the process of the audit, and I'm sure it will cover some of the substance, but these search terms are actually directed at discussions around the peripheries of that, where Mr. Phillip would have been talking about what was actually going on in 2014, and that may or may not actually have been a conversation connected to the audit process, although it may have been prompted by it. So we think that the audit search won't capture everything that is relevant here.
Yes, thank you very much. Well, I have no doubts at all about the relevance of this. Mr. Phillip being the signatory to the report, and the issue of discussions around the content of the report is potentially significant outside the terms of the report itself. So far as relevance is concerned, that is a criterion that is, in my judgment, undoubtedly satisfied. I'm slightly troubled by the question of proportionality, as Mr. Conti puts it, but there will inevitably be overlap with other search requests and indeed with other custodians, but deduplication should essentially sort that out. So I'm going to order that the search terms be used in the manner that the claimants have requested.
Thank you, my lord. Perhaps I might suggest that's an appropriate time for the transcribers. I understand that they might need a break, I think.
Yes, very good.
I'm grateful. Yes. We'll after the break, we'll move on to the claimants, custodians in that case, Your Honour.
Very good. All right. Well, we'll take 10 minutes now, please.
Thank you, my lord.
Thank you.
Yeah. Yes, the claimant's documents.
I'm grateful, Your Honour. So the general position is that the defendants had previously sought to add terms into the list that the claimants had prepared prior to the last hearing, and which Your Honour had approved subject to the defendants' opportunity to make counter proposals. So the claimants' general position was to resist those additions. Overnight, we have accepted most of them. Where the objections lie are in relation to terms that are simply too generic, and we say they're not directed at issues, or which cover ground that is already covered by other search terms. And that's our basic position. In relation to the generic terms, where possible, we have suggested a tweak to make it less generic and more suited to what the term is supposed to be about. So we say that the question for you is whether it's fair and proportionate to add more keywords to the list being used by the claimants. And I say that in particular because, as Your Honour knows, following the previous hearing, we said we wanted to get on with the exercise. We are getting on with it. We have done the COW teaching review. It will have to be redone. We accept that because additional documents are going in. But Your Honour should look at the proposed additions and scrutinise whether they're really necessary. Second, so that's the sort of the point of principle. I then have a few overarching points in relation to themes and the keywords, which Your Honour will see in a moment. And there are three of them. First, Your Honour will see that the defendants have added references to Alpen into the searches aimed at the transfer of business from BSA to D5. But this claim is not concerned with the transfer of business from BSA to Alpen Capital or to Alpen Capital Corporation Limited, the shareholder company, or Alpen Asset Advisors. So in my submission, those additions are unnecessary and merely serve to inflate the documents that will be captured and which will have to be reviewed, but for no gain in terms of relevance.
The only very broad point in relation to that, Mr. Sampson, is this, that supposing the shareholders agreed that they'd carve up the company's business between the two of them, which on one view of the way the defendants put their case is what might be thought to have happened. In those circumstances, references to Alpen getting its cut at the same time as D5 got its cut would be highly relevant, wouldn't they?
Well, I see that, Your Honour, but I don't think that's the case that's being advanced. And in the pleading, we refer to the discussions between the shareholders.
I'm sure it's not the case being advanced as such, because it doesn't help the defendants if that is so. But nonetheless, the documents would be very illuminating. Just suppose, for the sake of example, that is really the true position, that the parties agreed that the company's assets, when I say the parties, I mean Alpen on the one hand and the Bank Sarasin on the other, agree they're going to dissipate the company's assets by taking whatever share of the business each of them could grab. Not a wholly unrealistic hypothesis. That would advance the liquidator's case, wouldn't it?
Well, it may do, Your Honour. I mean, I think the short answer to that point, which is of course an interesting point about the way the case might work, is that we have pleaded the discussions between the shareholders, and obviously there are,
Yes.
Mr. Walia is a custodian, and there are searches in relation to the valuation issues and the buyout discussions, and so we're capturing the shareholders' discussions.
Yes.
But at the claimant's case is that those were ultimately unproductive discussions. They didn't lead anywhere. There was at one point a proposal made by Mr. Walia that the shareholders would carve up the business. He said, fine, we can do that, provided that that there is a distribution of the reserves of the company to the shareholders. And the defendants said, no, we're not going to do that. So we say that actually came to naught. So it's an interesting line of inquiry, but we say it's actually not borne out by the events, and it's not the case that my learned friend is running. And if I could ask Your Honour just to pick up the skeleton again, because I don't want to belabor these points, but paragraph 52 of the skeleton.
Yeah.
We've got an authority. It's from the Trucks competition litigation, Royal Mail Group and DAF Trucks Limited, in the Competition Appeals Tribunal.
Yes.
And I just ask Your Honour to read that.
Yeah.
I mean, it's the point is, curiosity is not a reason to order the production of documents. So our basic point on this is, and I don't want to push it too hard. Ultimately, if you're against me and you think that these should form part of the search, so be it. We'll do it. But our sort of starting position was that this case is really about the transfer of business to D5.
Well, it is. There's no question about that.
But I mean, that's the point I make. That's what we say is an issue, and that's why we have taken the approach, as Your Honour will see, of deleting the references to Alpen where they've been inserted in relation to those transfer of business type search terms.
Which document should I be looking at now in relation to the?
We will get there, Your Honour. I just want to make some general points about what you'll see as we go through.
Sorry.
If we may. Then the second general point is that there have been lots of additions that relate to the credit policy issues. And the defendant's case on this is that there's a breakdown in the relationship between Mr. Walia and the bank because of changes to the credit policy of the bank that were imposed on the business in Dubai, and they fell out over that. And therefore it's an important topic for disclosure. However, and this is one reason why I didn't want to take Your Honour to the list immediately, because we have to see another document first. At 3102, this is, I've taken you to the sort of middle, but these are minutes, board minutes from, sorry, I'm going to have to scroll back up to check the date. The 17th of December 2012, that's at 3097. But the point that I want Your Honours to look at is at 3102, and it is item 2A. At the bottom, EVC and CEO, who at this time is Mr. Walia. And if Your Honour just reads that bit, and then over the page, the sort of 2 bullet points that follow.
Sorry, EVC.
That's Executive Vice Chairman and Chief Executive Officer, Mr. Walia.
Thank you. Yeah.
So Your Honour can see Mr. Walia is complaining about the change in the credit policy and the effect it has on the business. And this is a theme that continues through the board minutes. We cited them in our skeleton. We don't need to look at all of them. I mean, I can just take you to the end point, which is at 3717. I'm sorry, 3716 of the bundle. And this is Mr. Walia's letter to the chairman of the board of BSA, and he says...
sorry, bear with me a moment.
Of course,
got there yet.
I'm sorry, I thought you had got there.
No. Yeah. 6th of June letter.
Yes, to the chairman of the board of BSA, and Mr. Walia says, this is to inform you I'm stepping down from my position as executive vice chairman and CEO. And then he says there are many reasons, and those reasons are over the page. And item 2 relates to the current business policies. So I just ask Your Honour to look at that.
Yeah.
So one of the reasons that prompted Mr. Walia's resignation as CEO is the approach that was being taken to the business. So that's the credit policy issues.
Yeah.
And that's in June. And then Mr. Walia resigns as director. So that's his resignation as CEO. He resigns as director of the company shortly afterwards when he learns about the fact that clients were going over to D5. I don't immediately have a bundle reference for that for you, Your Honour. I'll try and find it as I go. But we said that's not it. I'm so sorry, Your Honour. If you just bear with me one moment. If Your Honour goes to 3813. I'm just showing this to Your Honour because it will be relevant in a moment, but we might as well tie off the resignation of Mr. Walia. You see that this is an email from Mr. Walia to the board, and he says, rather than dealing with each of the issues in turn at the beginning of the second paragraph, let me instead confirm my immediate resignation from the board of directors. So this is in June 2014. So this is when he resigns and drops out of the business, both as CEO and as director. Now, the point that I wanted to make in relation to these documents is that the dispute over the credit policy is not really seriously an issue. And we say that is important when we come to look at how extensive the searches should be. And then the third overarching point that I have to make is that there were previously proposals to search the term Corman to capture references to Mr. Corman in the documents. And we say that it's not necessary to do that now because Mr. Corman is being added as a custodian. The documents that the liquidator holds in respect of him will be searched. And so rather than searching for instances where his name appears in other people's documents, we can just search him for the issues. So we would propose to add him. We have proposed to add him, and it's been accepted to the same group of custodians as Mr. Walia, Mr. Lakshman, and Ms. Ahmad. Now, that's all I wanted to say by way of framing what's going to come next. There are specific points that we need to look at, and those have been identified in a keywords list, a revised keywords list that was sent to you overnight. If Your Honour prefers to look at it on screen, I have the page reference.
Excuse me, is this the 18-page document headed Claimants Amendments to Date Ranges and Keyword Schedule?
That is it. Yes.
Yeah, okay.
So the change, so the approach that we've taken is not to go through a schedule. I mean, the schedule that existed outlining the disputes is the 86-page schedule attached to my learned friend's skeleton argument.
Hold on, I've got two different versions of this.
You may have a clean version and a marked up version, Your Honour. It would be more helpful to look at the markup.
Yes, okay, I've got that.
That shows the changes that have been made. So my learned friend attached an 86-page schedule to a skeleton argument. It's very useful for understanding what the issues were between the parties, but I'm afraid it was not possible for me to work through that and do a sort of counter schedule in the time available. The approach that we took was to look at it, make amendments to the list of proposed keywords to reflect what was being offered by the defendants, but also to show the areas in which the claimants were prepared to compromise and just sort of let keywords in or to tweak them. And that took us about an hour. So it was an exercise that we were able to do quickly, and we took the view that that was better because it meant we could get something to my learned friend to look at in the evening. And we also say it's better as a reference point for the court this morning because rather than looking at some search terms line by line, split out for each custodian, as Your Honour will recall, the way that this is organised, custodians are grouped up together, and so we can actually deal with multiple custodians in one go whilst we look at the disputed keywords. So my proposal is to go through this and for the parties to address Your Honour very, very briefly on the points that are an issue in it.
So this is, in its marked up form, is the 21-page document.
Yes, I think that's right. If I just...
sorry to interrupt my learned friend, but I would object to that way forward. I'd like to make some submissions on the point if that's what he's actually proposing that we're to do.
Well, my learned friend is welcome to do that.
I'm happy for him to go through it, but I mean, I'll be frank, I don't think that it's going to be a useful exercise to go through the table. If he's suggesting that he makes submissions on certain entries and then I make submissions in reply, in a moment I'll be making submissions about how it's just, I cannot evaluate the table as it's been set up. I mean, it would have been a much more helpful exercise for my learned friend to go through at least some parts of the schedule, because then I could understand which particular custodians it affects, in particularly as regards the nature of the objections contained in the table. And I can take the court through it, but it's just not, I'm just not in a position based on what was a 1-hour job done to a document that I can't easily translate over to the schedule to go through, because I do not actually understand the implications, because you actually do need to do it line by line, and I can explain that in due course. But we've hit a roadblock here in my submission, my lord.
Your Honour, this is completely overblown because the points that are taken by my learned friend in his schedule go for each of the custodians in a group. So we can just look at the keyword term that's proposed. We can talk about whether or not it's relevant, or whether or not, and as I said at the outset, the points are, our points are, they're either too generic or they cover ground that is already in this schedule. We can identify those points very easily by reference to the schedule.
That's not quite right, my lord. So let me give you an example. So my learned friend, you'll remember before the last disclosure meeting, reinvented the wheel. So the parties had produced a consolidated keywords list that was separated by dates, custodian and search. Very clear. Everybody knew what the position was. But 40 minutes before skeletons were due, my learned friend reinvented the landscape and he's grouped them together. Now, the problem is that has caused a lot of time wastage, but I'll leave that aside. But the problem is that hides certain issues. So, for example, you may have 3 custodians in one group, and disproportionality is a key argument. And when you run the same search against the 3 custodians, the hits may be 10, 1,000 and 15,000. Now, we don't propose to take the disproportionality objection about 10 hits, unlike my learned friend has in his schedule, but we would take the disproportionality objection about 50, we would object to it, any disproportionality objection to the lowest number, but we wouldn't object to it about the higher number. That's just the way it is, because disproportionality is metrics driven. And so you can't just say, let's do it line by line. The other problem that I have, I must say, is my learned friend changed the debate. He changed the debate about this particular topic. We were exchanging tables, and then the last time they sent over a table, they sent over a schedule where they had very clearly set out, and it was extremely helpful, what the proposal is, what their objection is. My instructor spent days because he changed the landscape, he changed the debate, and we responded in terms. The table then shows what our response is and what our counter proposal is. And I have several examples that show why it's just not feasible, and it's not a high-level review, and it's not for today to go through the actual amendments he's made to the table. It's, I think, a much more appropriate way to have them engage on the table, be cooperative, give the responses, and then we work out where we are. I mean, there are certain problems in the sense that my learned friend can't go changing the debate, have us respond to it, and then switch to another language. It just doesn't put us in a position where I can engage effectively, and this is meant to be a cooperative process.
Your Honour, we're in the middle of a hearing, and this came up at the end of the hearing yesterday, and everybody agreed we would try to do this in a high-level way. And if my learned friend wants to take points about the number of hits for particular searches in relation to the searches for my own custodians, well, then he's free to do so. He has his schedule. He can pull out the numbers that he thinks are relevant, and he can tell you about them.
I'm just simply not in a position to refer to the schedule with that kind of ease. It's not that easily translatable, I'm afraid.
Well, I'd like to just finish my point, but my learned friend cut across me. That's the exercise that I've done. So where the hits are relevant, I'm able to tell Your Honour what they are.
Well, I'll tell you what I'm going to do. I'm going to listen to what Mr. Sampson has to say about his new schedule. I understand exactly what you're saying, Mr. Conte, that you haven't had really the opportunity to transmute the various objections from your much longer schedule to see how that stacks up against this, because it's done in a different format with all the custodians put together. I understand that point, don't get me wrong. So I'm going to listen to what Mr. Sampson has to say, and it may be that I'm not going to be able to provide any guidance at all today, because we again have this business of ships passing in the night. But let's see where we get to, because it may at least be helpful for you, Mr. Conte, to hear what's being said, and then to have the chance to reflect on it in the context of your own schedules, even if I can't make any decisions today, because you're not in a position to make submissions about the particular format. You understand?
I'm very, very grateful for that indication, my lord.
We'll see how we go. I've no idea where this will end up, but I think it must be helpful in the longer term, at least for Mr. Sampson to outline what his approach is.
I'm very grateful, my lord.
Thank you, Your Honour. I mean, Mr. Montague-Smith said yesterday that we'd all be looking at the keywords together, and so the proposal is for me to set out our position, and Mr. Conte knows what objections he's taken in his schedule, so he can tell us.
Well, let's see where we get to, Mr. Sampson.
Yes. No. Well, I think the exercise will show that this is eminently doable. Now, the first point. So we're on page 1. The first point that arises is actually the date range in relation to Mr. Walia. So my learned friend wants to search through to May 2016, and as Your Honour sees, we propose to search through to December 2014. And as we saw a moment ago, the reason for that is that Mr. Walia resigned as the CEO and as a director of BSA in mid-2014. So, and by December 2014, the scheme had been executed and the business at BSA had been wound down. The only thing that BSA was then involved in, really, was the Carafi litigation. So we say that Mr. Walia is no longer involved in the business, I mean, in the latter half of 2014, but we'll search that period in case he's got anything to say about the scheme. But thereafter, Mr. Walia's contribution is unlikely, really, to inform the issues, because he's not somebody who's managing the business, such as it is by that point. He's merely the representative of a shareholder. I mean, in relation to the Carafi litigation, the pleaded issue is whether BSA was prospectively insolvent by June 2014, i.e. between the trial but before the liability judgment. And that's pleaded in paragraph 93 of the particulars of claim. And so the detail about subsequent litigation in relation to quantum and the appeal, we say, is not really relevant to the question, were the directors in a position by June 2014 to appreciate the risk that the company faced, and did it have enough cover to meet that risk? So that points towards searches that are confined to 2014 in relation to Mr. Walia. Now, this matters because the difference made by the extended date range is large. There are schedules produced by Ancora which show the number of documents, not the hit rates, but the number of documents generated by the claimant searches and the defendant searches, and those are at 4968 in the bundle and 5092 in the bundle. We don't need to go there. The difference is 57,889 documents if you search Mr. Walia's documents through to May 2016. But for what benefit? As I just said, he's not involved in the business anymore. And insofar as he's got comments on the Carafi litigation because he's a shareholder, that doesn't really go to the issue of whether the board knew in 2014 that the company was prospectively insolvent. So we say that the date range should end at December 2014. But if Your Honour is against me on that, then we say that the date range should only be extended in relation to the Carafi litigation and solvency keywords. Because as we understand it, that's what the defendants would be interested in seeing.
What about the point that I raised with you a few moments ago about Mr. Walia trying to take his cut of the business?
Well, that all happened much earlier because the discussions between the shareholders were going on in early 2014.
Well, I understand that, but remind me as to the dates of onboarding for D5 of clients extended to what date?
Well, the way that it's being searched is that it extended up to December 2014. I mean, I think the claimants would say that there may have been solicitation going on after that date. But what happened is that you had the first period over the summer where the relationship managers were resigning and then getting in touch with their clients.
Yeah.
But then there's a body of clients that were left, and the board of BSA took the view that they needed to release the clients in order to wind the business down, which they wanted to do by the end of the year. So they sent termination letters to those clients. And so the example that we've looked at before, United Arab Shipping Company, which involves the telephone call between Alice Brander, the person in the booking center, and the client, that is an example of a client who had been terminated and is then contacted by people from D4 and D5 in order to get that client to join up with them, having been terminated by BSA. So
you say your date range encompasses that?
Yes, it's all done by the end of 2014. Now, the way I thought this would go is that Mr. Conte would then tell us what he thinks about that.
Right. Well, Mr. Conte, I think it is probably appropriate that you either say you can respond or you can't respond, and if you can respond, then do. And again, we'll see where we go. Is this something you can respond to or not?
May I just have one moment so I can get the table?
Yes.
So the response on date range is at the bottom of the table. It is at 7431.
At 7431.
The footnote at the bottom of the table is the defendant's position. The defendant's position is that Mr. Whaley's search range should extend to May 2016. He was a shareholder representative of Alpen and remain involved in BCA following his resignation as CEO. His knowledge of events is therefore central to many of the facts in issue. By way of example, the quantum judgment which ultimately led to BSA's insolvency was handed down on 7 October 2015. Mr. Whaley was seemingly a representative shareholder of Alpen at the time. The shareholder reaction to the quantum judgment was an important issue. Now, if he wasn't involved in the business, there would have been no reason for him to be using his BSA account. But my learned friend just told you that the numbers, the differential in the searches is quite high. And so there's a question there about what is in those documents. But ultimately, what my learned friend does is he seeks to sidestep the issue by just focusing on Mr. Wiley in one capacity. But it's the capacity in him as a shareholder that we're actually interested in. And it is relevant to the issues. And we have discussed, and your lordship has made the point about, ultimately the issues here are just simply beyond his capacity as a director, and we say that the extended date range is more important. The only real objection that my learned friend could make is based on disproportionality, but we say the issue is an important one. And just as my learned friend was able to override a concern about disproportionality earlier when it came to our searches, we say it should be overriding here.
Well, Your Honour's heard what I've said about the relevance of the quantum judgment and the appeal, so I don't need to repeat those points. But the solvency question relates to what was happening in 2014.
On our case, it doesn't.
But on our case, that's not the case, my lord, just to mention.
Yeah, I'm being slow here, and you'll forgive me because I'm way behind you in my consideration of these matters. But...
And my lord, this is grist to my mill about how my lord asked for high level points, and I've misunderstood the enterprise. What I thought the indication from your lordship was yesterday is be reasonable, go away, let's try and get this done tomorrow, narrow the issues, come back to me with high level points. What my learned friend now I think proposes to do is to get into the thicket, get into the weeds, make very detailed arguments, which of course was the purpose of the table. And this is now twice. This is the second time I'm here scrambling because I have 3 different documents. I have, and I should say, it's not only the case that there's 3 different documents, but all the amendments on the table don't match the amendments in the schedule. They haven't been carried across. And I can take your lordship's example. But I'm really at a disadvantage, and I have to do my proper service for my client, and I can't do that on the hoof. But my learned friend insists on reconceptualising the landscape the night before we're about to have a debate. And so, although I can respond on this point, again, it's a matter that would require, again, when we get to further points, I'd have to compare what's in the responses tracked across to the table. And so I am very concerned about making these submissions without effectively being able to prepare properly. What I thought the claimants were going to do was to strike through a lot of the objections. I'm told, and we haven't had a lot of time to check this, but there are still hundreds, because my learned friend took the approach of grouping in order to make life more simple, but that doesn't work because, as I say, some objections are different across categories. And so again, I say, this is not going to be a fruitful exercise. I'm happy for him to run through it, but if at the end of every objection his position is, well, let's see what Mr. Conte has to say about that, Mr. Conte's opening remark is going to be, it's very difficult for me to make this argument on the hoof. It would have been helpful. And I heard my learned friend say, well, we only had an hour, we thought it would be helpful. Well, we spent several hours whittling down our list to the absolute minimum, first of all. Second of all, producing a table that had a very clear objection in the last column that was intelligible as a standalone document. What I'm getting now is objections that move away from the table. I'm getting now additional arguments, and I'm having to compare 2 documents that I simply cannot do on the hoof. And so I'm very concerned about the process. I've already said this at the second disclosure hearing, but my learned friend insists on having this kind of debate. And I must say, I object. The more appropriate way forward in my submission is my learned friend should go away. He should fill out the table, which I must say he set. I didn't set the parameters for this debate. The original objections table was drafted by the claimants, and it was an excellent idea. It was a fantastic idea because it made it plain. And it may well be that when my learned friend fills in a new column that responds to all of our objections, maybe we can do this on the papers. If they're sensible and they concede points and they set them out, first of all, there may be a very narrow range of disputes, which means we may not have to be here for hours upon end. And second of all, it may be that we can do it on the papers. That's a much more efficient use of court time than me having to scramble because I'm not quite sure what my learned friend has to say.
Your Honour, I don't want to push this. I'm slightly surprised by what Mr. Conte says, because he and I have been dealing with this. We were at a hearing before you recently. We think that, that as advocates we ought to be on top of the issues, and we ought to be able to address Your Honour briefly in relation to the points that arise. I mean, we've been talking about these search terms for a long time, and for my learned friend to say that he doesn't quite know what his case is on particular search terms is somewhat troubling. And what we had envisaged was that we could go through what's an issue. The number of things that you have to look at is reduced because of the grouping of the custodians, and that has always been the format. But that has been the format of this document since it was produced before the last hearing. So it's not a new document overnight. It's just a document that has been amended overnight to take out things that we had objected to and to introduce slight amendments that are either common ground between the parties, because I've taken them from Mr. Conte's schedule, or they are proposals like, I mean, if we look at item 2 further down on this page, it's aligned, we say it's too generic, but the point that Mr. Conte has made about this in his schedule is that alignment between the shareholders is a topic they're interested in. So we say, well, let's search for aligned and shareholders so that it meets his point, because otherwise we'll get all sorts of documents talking about alignment of things which are not relevant to the issues. Anyway, so I mean, it ought to be a simple exercise that can be dealt with in brief oral submissions, and Your Honour could say this one is in or it's out. But my learned friend doesn't want to embark on that exercise. If he's genuinely unable to do that, then it means that the parties have to go away. We can't use the time that's been set, judicial time that's been set aside today, and we're going to have more time-consuming and expensive meetings, because every time these meetings require a lot of preparation. They take a lot of time out of the parties' diaries, and ultimately that professional time costs money. So it's quite an expensive way of doing it.
Just to make clear, that's not my proposal, my lord. What I propose is, and this is the simple proposal, the claimants started us on this journey. They've changed track, but I'll leave that where it is. They started on the table, and it very clearly shows our proposal, their objection. We have then spent days, and my learned friend talks about time wasted, days. My instructing solicitors worked tirelessly to produce an excellent table where they set out the reason for the objection and our counter proposals. What I am proposing is my learned friend goes away, perhaps spends more than an hour, fills in another column in the table, and then we have a nice table that sets out everyone's position. If the claimants then will be reasonable and show us on that table what is now gone, we will then have a table that covers the field. No need to have a meeting. We can do it in correspondence, hopefully whittle down the issues, so that rather than going back and forth and wasting time essentially because I'm not in a position to make the argument in full, get the categories down to the absolute minimum, and then if need be have a hearing or do it on the papers. I mean, it may all be in the table, my lord, in which case I'm not sure if my lord thinks he needs more guidance, we can come back for a very short hearing for an hour. And my learned friend can't say, well, that's outrageous, another hearing before Christmas, because his draft order envisaged we should be coming back for non-custodial keywords on the 17th or the 18th.
Well, Your Honour, can I just come back on that point? Because, of course, the non-custodial issue is a separate one and also needs to be dealt with. I mean, the claimant's position today is that the parties need finality, or as much finality as they can get on the keywords. Now, that was particularly important when the deadline was the end of the year or was going to be the beginning of January. I appreciate that there's now more time. But if we walk away today without looking at these keywords and making a determination on them, then the position that we're in is actually that the claimants are stuck, because we've now agreed the keywords for the defendants. They can go away and do their review, and they can get started. Whereas my clients, they've sort of started the review, but they're going to have to redo the cow algorithm teaching review, because there will be new additions to the population, because we've agreed things. But there's a rump of points that are not agreed. We'd like those to be determined today so that we can be in the same position as defendants after the hearing, i.e. we can get on with our review exercise. And obviously we're going to have a progress report by March. Whereas my learned friend's recipe is for the parties to go away, try and whittle it down, have back and forth, have the lawyers spend lots of time writing letters and filling out schedules. Whereas this could, I mean, we've wasted a lot of time debating about the form. I mean, we could have probably got quite a long way into this schedule. I could have sort of made a point on a keyword. Mr. Conte could have made his point on the keyword, and Your Honour could have said yes or no to it.
But that's the problem with my learned friend's submission. He makes an assumption that's just not correct. I could have made my points, open brackets, knowing fully what they are because I've looked at this in my format, close brackets. Mr. Conte can make his points, open brackets, even though he's going between two documents. I mean, it's just simply not an appropriate way forward. If my learned friend wants to start, if the claimant's position is hand on heart, they want to start tomorrow, my submission is they should just accept the defendant's proposals out now, which is pretty much what the defendants did, if that's what they want to do. If they hand on heart want to have a debate about this, then fairness demands that we have a proper chance to respond. It really does. And I must say, again, my learned friend said he spent an hour responding. There were several hours, I can say because I was in the room, there were several hours spent on the defendant's side making sure we whittled things down to an appropriate number of objections at a high level and setting out the basis in a separate column. So when my learned friend says, well, the defendants are ready to go, so it's outrageous that we then shouldn't be ready to go. The defendants are ready to go because they took your lordship's indication and they were incredibly pragmatic. And you even saw earlier, I got instructions during the hearing and I was instructed to concede to in the interest of fairness, again, we've been debating this for months, but my clients did not dig their heels in. They just said, well, this is fair enough. We want to get on with it. The claimant's position is not let's get on with it, because there are hundreds of objections. But you can't see that, Your Lordship, because they've grouped custodians together. You need to separate them, as they helpfully did in their original table, and that shows the different objections. Because again, my point is, if they stick to the objections in their table, which I don't assume that that haven't backed away from them, there are different objections. So they could have the same objections in relation to the group of custodians, but they apply slightly differently across the set, and therefore we do need to take some of them item by item. And I'm just at a loss at how my learned friend basically wants to push on through in circumstances where I've said it's not apples with apples. If he wants to work from my table, if he wants to work through and tell me what's agreed or not agreed from my table, his table that I've amended, fine, we can do that. But I would suspect he doesn't want to work from my table, because that's not where his amendments are. And so I really do think, I'm afraid, this is not something that I'm going to be in a position to have a mini moot on each point right now.
What I'm looking at, two questions. What I'm looking at page 7431 is the document that you, Mr. Conte, would want to work from. Have I understood that right?
Yes, I would.
Is there any reason, subject to questions of time, why I should not be looking at both Mr. Sampson's document and this document at the same time, and seeing if I can form a judgment by reference to both those documents?
If Your Honour can have them side by side, I can walk Your Honour through both documents. That's no problem.
And how long is this going to take, Mr. Sampson?
Well, I thought it might take an hour.
I just think that's wholly unrealistic. And the other problem is, with the best will in the world, Mr. Sampson's table has some errors that don't quite match up. So the new table has some errors that don't quite match up to this table. That was one of the points I was going to take Your Lordship to. But with the best will in the world, this table is 90 pages, perhaps. 85, and so the approach that we took, and what I say is the more appropriate approach, is for the claimants to go through, work out what's agreed or what they don't take objection to, and then just remove that and produce a new table. It's certainly not something now that we've already been going for 2.5 hours. We've got maybe however long Your Lordship is willing to sit, but we've also got the one issue remaining on the agenda. And my submission is it's just not something that's going to be a good use of the court's time. And I also make this point. Your Lordship was very clear yesterday. Do you want me to go away and look into the weeds, or are you happy for me to take this at a high level? And we took that indication seriously, and we changed the debate to a high level one. This is not a high level debate. This is let's get into the weeds.
Yeah, well, I'm with you on that, Mr. Conte. The only question is what I can usefully do today. I mean, I'm just looking at this particular item, which may or may not be a good example of the rest. I'm certainly, if we have to look at 85 pages, we're going to be here forever and a day. That just isn't realistic at all. If I know what Mr. Sampson has tried to do is to group them. You say that they can't be grouped in the way that he does. But let's just look at this particular item, and then I'll decide where we're going to go. I'm looking now at page 7431, Mr. Conte. And do I understand that so far as are we simply looking at item 1 here, or are we also looking at items 2 and 4? Mr. Sampson.
Well, Your Honour, so the way this works is that if you're looking at item 1 on this page, that's from Mr. Walia, and the defendant's request is AK or Karafi and judgment or liab or appeal at the end. At the end. And if you look at my schedule, that's the change we made. So we accepted their proposal and reflected that in our keywords. So I don't understand what all the fuss is about.
Right.
And then if we look at item 2, this is a sort of point about where dispute then comes out. So it's the aligned proposal. the defendant's response is that the proposed search term is relevant. They say it's aimed at misalignment between shareholders. And their proposal is that the court should order a search in particular date ranges. But our proposal is, let's not worry about date ranges and making this fiddly. Let's just search for aligned and shareholders. Much simpler.
And so again, my learned friend's now given the reason. Apparently it's simpler, but what he hasn't done is, so he said it's simpler. I don't really understand that to be an objection or a valid one, but also he's using the words. And so he hasn't accepted the counter proposal. His objection then would be, ours is simpler. Don't think that's a good reason. But also, I mean, the actual string now that he's amended overnight has shareholders in the plural and therefore is going to be narrow. So it's going to be aligned and shareholders rather than say shareholder asterisk or something else. So it's a query about what it is going to catch. It's just going to be too narrow. And again, this is an example of something where the reasoning as to why he doesn't accept this counter proposal is helpful, because my learned friend's basis now is ours is simpler. That's an invalid objection. The objections my learned friend took in the table were in the nature of it's disproportionate, it's generic, it's not sufficiently related to the issues. He took an objection about duplicity, and in many instances that was embarrassing because he just said, well, it's covered by other searches and didn't articulate the other searches to which he refers. And so if we're going to do this properly, if claimants are not going to be commercial and don't want to make concessions to get this done, then we should do it properly. And I'm afraid it's just not the way that we say this should proceed. But again, the devil is in the detail when it comes to the counter proposals, and my learned friend now has shown why. His objection to our counter proposal was ours is simpler. That's not a good reason. But what he hasn't done when he's produced his new table is he hasn't given me the basis for his rejection of my counter proposals. Is it because they're disproportionate? Is it because they're irrelevant? Is it because he takes the generic point? Again, I need to be clear as to the basis for the rejection of my counter proposal to know whether it's in my client's best interests to be pressing the point or not, and to advise them and then to take their advice.
Right. Okay, well, I'm going to make a decision about this item 1 with both these documents in hand, and I need just to ask 1 or 2 questions.
It has to be item 1 while you're...
So, looking at what you're saying about this, Mr. Conte, and the search term itself, AK or Carafi and open bracket judgment on liab asterisk or appeal. Looking then at Mr. Sampson's keyword, AK or Carafi, and judgment or appeal or liab, which is a slightly different format. Is there a problem there? Or are we simply arguing about date range?
That's an argument about nothing. That was common ground. It's just that liab and appeal are reversed in the order that they appear.
Well, that's why I asked the question.
I mean, that's just a point of common ground. And I mean, unfortunately, we've had a very long cloud of objections.
So we are just talking about date range on the basis. I'm looking at the defendant's response here.
There's no point on date range in relation to this item. This item is agreed.
Walia more generally.
There's a date range,
I think,
in relation to Mr. Walia, which I
is
already explained to your honour. So that's
more general, my lord.
That's the searches of all the keywords in relation to Mr. Walia. I've set out my client's position on that, and Mr. Conte's response was, he's not in a position to argue why Mr. Walia should be searched through to May 2016, as my learned friend suggested.
I see. Well, this rather illustrates the problem. I hadn't appreciated that when you're talking about Walia, you're talking not just about item 1. You're talking about everything in relation to Walia. Is that right?
Yes, but that's, I mean...
And therein lies the problem with the approach where it's not set out in a table that's clear, my lord.
No, it isn't. No, I'm not prepared to go through this, Mr. Sampson. It just won't do. The reality... I hadn't appreciated that. I thought we were talking simply about item 1 and a date range for item 1. It's going to take forever and a day if I have to try and look at both both forms of the table. There's one thing I will let you do, Mr. Sampson, is that you can make the points you want to make so that Mr. Conti can go away and think about them, and then come back on it. I should say at once that the chances of me looking at anything in detail before we get to the Christmas break is absolutely minimal because of an arbitration that I'm in from the beginning of December. So that the chances of you being able to come back for anything more than an hour in the early morning for a hearing that resolves a very limited number of points are very limited indeed. And I'm unlikely to have the opportunity to work through long schedules in the evenings following extremely tedious arbitration where I have to read transcripts overnight. So that the burden will be on the parties to reach an agreement following the submissions that you make now. And what I will do is then just simply listen to your submissions, ask a few questions. And if Mr. Conti wants to ask a question or two for clarification purposes, that's fine. That means essentially, as I understand it, that we're likely to run for another hour or so, if I've understood you correctly, Mr. Sampson. Is that right?
Well, Your Honour, I think what I would say in response to that is that there's really no point in me going through the schedule, because if it's not going to promote, if it's not going to result in a decision, then it's wasted time. And I'm afraid to say that what Your Honour has just said rather illustrates the problem, that we now are faced with a choice. You know, Mr. Conte has he's refused to engage in the oral advocacy based on the documents that the parties have prepared and which we're all familiar with. And so we now have to go away and try and deal with this in writing, but knowing that we won't be able to resolve any disputes before Your Honour, before Christmas. So, I mean, as my learned friend submitted to you, the position that we're now in is simply that we have to accept all of their counter proposals if we want to start tomorrow. And that, in my submission, is highly regrettable. But we will move on. The next...
Well, unless there are, as I say, some very specific high-level points. I mean, there's absolutely no doubt in my mind that I was told yesterday that we were only going to be dealing with high-level points and not with nitty-gritty
Then I come back
of an 85-page schedule.
Well, I understand that, and I didn't want to go through the 85-page schedule because it's not really necessary. But I'll come back to the general points then, which is that the added references to Alpen in relation to transfer search terms, and if Your Honour wants to see an example of that, then we can look at an example.
Well, you take me to what you want to take me to, and we'll.
Yes, well,
we'll try and deal with whatever high-level points capable of being dealt with here and now, and see how far we get.
So the first point then, if we look at examples, items 44, 45, and 46, and 47 in this schedule that we've produced.
In your schedule?
Yes.
Yeah. 44.
I'm afraid I don't know what the page of the bundle is.
7552.
I'm grateful, thank you.
So
the point here is that the defendants have introduced Alpen or AA. We've struck through those. Can you want to see that?
This is in relation to searches of what?
So if we go back to the beginning of the schedule, this is the group of custodians who are Rohit Walia, TM Lakshman, Samina Ahmed, and now
right. So this is for
Hans
the lot.
Coleman. This is the lot. Yes, and this is a search term that will be searched for all 4 custodians.
Yes. Okay, I've got you.
So this is why I submitted at the outset that we can deal with 4 custodians in one go here.
All right. Well, let's see if we can do that. That is a high-level point.
But so the point then is that in this example we have Alpen or AA, which has been added in, and we've struck through it.
Yeah.
Because as I said at the outset, we say that this case is not one that relates to the transfer of business to Alpen or AAA. Your lordship had the point about carving up for the business on that. And then if we go to items 72, 73, and 74, the search terms are now different because this is the transfer, client, business partner, relationship, and so on. But the point is the same. These all go to the same issue. And here we have the introduction of Alpen Capital.
I'm sorry, I can't find items 72, 73, and 74.
If you're on a scroll, it's 7553 in the bundle. It's page 5 of the schedule. If you're looking at the pagination at the bottom, that's page 5.
Yes.
And you can see 72, 73, 74.
Got it.
These are the same sorts of search terms. And again, we have the introduction of Alpen Capital or ACCL. I mean, actually, those are different entities to the ones that were proposed, but it's the Alpen group. And this is a theme that's common to all of these kinds of search terms, and it appears in relation to all of the custodians in this list across all of the groups of custodians. And so the overall point we make, which will deal with all of those items, is that it's not necessary to add the references to Alpen related entities, because that's not where the business went. It's not where the relationship managers went. It's not where the clients went. So we don't need to search for that. So that's overall point 1. Then overall point.
Right. Well, I'm against you on that, Mr. Sampson, for the reasons I've already given. Well, it seems to me that transfer of business to Alpen could be highly relevant in the overall context. I can understand forensically why one or other party might want to avoid that as a possibility, but that's always seemed to me a realistic way of looking at the facts should the evidence turn out that way. So I'm against you on that.
I'm grateful, Your Honour, and we accept that, of course. Then the second overall point is that there were searches for Mr. Kuhlmann's name across the custodians. So if we stay in this bit of the schedule, and if Your Honour goes back to page 3, in fact.
Yes.
You can see there's a struck through item 45, which is just Kuhlmann.
Just explain to me how this works. Once you include him as a custodian, why does that mean that you catch everything that would otherwise be caught by this?
Because these search terms will be applied to Mr. Kuhlmann's documents. So this list of
assuming you've got them all, of course.
Yes, the documents that the liquidator has, which are captured as Mr. Kuhlmann's documents by Ancura, will then be searched with the search terms that we've included in this section of the keywords list. And so if we're doing that, then there's no need to search other custodians and indeed Mr. Kuhlmann's own documents for the word Kuhlmann.
Right.
So my submission is that where Kuhlmann appears as a standalone item in this schedule, we've deleted it, and the reason for that is that Mr. Kuhlmann's documents will be searched. And so we'd ask you to approve that.
Your reaction to that, Mr. Conti?
I find the objection just difficult to understand. I mean, that they have Mr. Kerman's, they've added him as a custodian, but there may be other relevant documents that refer to Mr. Kerman. I mean, it doesn't necessarily mean because you have his documents, you have every relevant reference to him. The second point is, and again, it's as clear from the correspondence, but I don't want to bore your lordship to take him to it. But it's been made quite clear that Mr. Kerman is a relatively central player on the pleadings to various aspects. They've accepted this, they've added him as a custodian. And so discussion of him in a different context, we say, would be relevant. It's just simply not understood why you would be deleting him. Also, the claimants do have a penchant for adding in names as search terms. They do that where the particular person is relevant. And again, we say here, Mr. Kerman is relevant on their case theory, and they've accepted him as a custodian. And so I find this submission difficult to understand now that they've added him as a custodian. And also, I mean, I don't really understand why you how you can consistently maintain the position that he's a custodian, his documents may be relevant, and that his discussion of him in another context is not relevant when, as I say, he's a custodian and he's referred to in the pleadings. So I think my submission overall is I really don't understand the point. And they object to him on Mr. Phillip, also not just on this group. So arguments about groups aren't necessarily helpful. And that also feeds my point about how my learned friend's reconceptualisation of the universe 40 minutes before skeletons were due for the last hearing has not been particularly helpful, but yet he insists on going back to that reconceptualisation. And I make the point again, this needs to be done in a way where if an objection applies differently to different members of the group, or if the same objection is made to a term relating to a different group, that needs to be cast into the light. Otherwise, your lordship may be making a decision based on imperfect information.
Well, if I can come back on that, Your Honour,
Yeah.
my learned friend simply asserts that Mr. Corman is relevant generally. I mean, we accept that he's a person that was involved in the business, and so his documents, such as we have them, ought to be searched in relation to the topics and themes that are captured by the keywords. But that's rather different to saying he as an individual has some sort of special significance in the case, and my learned friend hasn't identified any. He has said that we've added names in relation to other searches. I mean, for instance, we want the defendants to search Mr. Phillips' documents for references to Miss Brander in a particular time because he was in communication with her about the transfer of clients and the reconciliation of assets under management, as we discussed yesterday. So there's no point like that being made in relation to Mr. Corman. It's just asserted that he's generally relevant. But the search for his name in the documents will simply capture every single document where his email address appears, because his name is in his email address, and it will appear as the name next to the email address. So we say it's much better to just search Mr. Corman's documents for the relevant themes and issues, and that will capture what the parties ought to be looking at, and ultimately the evidence that needs to be brought to trial.
Right. Well, my view on that is that, as currently put, it's too wide, but that it should be capable of refinement in such a way as to limit the range of documents where Mr. Kerman's name is involved. I don't think it is sufficient simply to have Mr. Kerman as a custodian. There will be a need for something beyond that, and I'm going to leave that matter over, and the parties will have to seek to agree an appropriate refinement of terms that covers the areas where Mr. Kerman's involvement may be relevant.
I'm grateful. So we will expect a proposal from the other side about how they think Mr. Corman has special relevance, and therefore what his search term can be narrowed down to, because this is
but I mean, on that point, I mean, I just pause there for a moment. The claimants actually have his documents. We don't have his documents, and so it may be more helpful for the claimants to come with the first proposal.
Well, I've set out our position on that, and Mr. Conte is trying to put the shoe back on my foot, but he's the one who's pursued inclusion of the term.
Well, let's. I think the defendants could have a stab at it first, saying why they think his involvement matters in this context, and therefore the sort of terms that could be applied to refine it, so you don't get multiple references to Mr. Kerman in correspondence that have no relationship or relevance to anything in issue. So the defendants will have to indicate the potential relevance, and then there can be a sensible discussion about what the documents may or may not reveal. Right. Okay.
I'm grateful on that. And then the final point, which is the one that we've discussed earlier, is about the overall date range for Mr. Walia. So let it be absolutely clear, and this is back at page 1 of the schedule.
Yes.
Let it be absolutely clear that this is a overall date range proposed for the searches of the terms in the schedule in relation to Mr. Walia. And the defendants know that. There's never been any doubt about that, because they've made specific date range counter proposals for other custodians. I mean, you can see that you're on this page. There's a item A, date range of February 2014. That date range gets applied to specific keywords, and that's a technique that my learned friend has used in relation to search proposals. So there shouldn't be any confusion.
Mr. Sampson, What document are you referring to?
So we're still in our schedule.
Yes, yes.
And on the first page, in the date ranges column, there's the overall date range for Mr. Walia. And I'm simply making the point that this isn't news to my learned friend. This is the way that this document was structured prior to when it was provided to him prior to the previous hearing, and hasn't changed since. And if you want to look at the bottom under Hans Kurven, there's a square brackets A, date range of February 2014. That applies to specific keywords in the schedule. So not all of them, just ones where a narrower date range is thought to be appropriate, and that's a technique that the defendants used. So I'm simply making the point that they know how this document works. Now, I made my submissions about Rohit Walia and his overall date range. Just to refresh your memory, it's that he ceased to be involved in the business in mid-2014. The business itself was wound down by the end of 2014. The only thing it was involved in thereafter was the Carafi litigation, and the Carafi litigation is relevant to the solvency question. And I'm going to take Your Honour to the pleading on that, just so that there can be no doubt. So if Your Honour can go to page 39 in the bundle. This is the amended consolidated particulars of claim, and if Your Honour looks at paragraph 93, this is what we plead in relation to the prospective insolvency.
Yeah.
And so, we say that the solvency question revolves around what the directors knew at the time. So by June 2014, which is the latest date that we put for their knowledge of the prospective insolvency. And at that point, that was between the trial and the liability judgment being handed down. And so in my submission, events after December 2014, which relate to the quantum litigation and the appeal, don't tell you what the directors actually knew at the time, by June 2014, as to the company's solvency, i.e. the risk that it faced of an adverse judgment, and how they responded to that.
Sorry, I thought you were finished.
I haven't finished, Mr. Conte.
Apologies.
And so we say that extending the searches generally to May 2016 is not necessary because of Mr. Walia's involvement. We say it's also not necessary in relation to the solvency issue that was captured by my learned friend's footnote in his schedule that we looked at. But if Your Honour is against me on that, then the extension of the date range should only apply to those points that my learned friend says are relevant, which is the Carafi litigation and the solvency search terms. So our primary position is that it just shouldn't extend to May 2016 at all. But if it is to extend to May 2016, then it should be in relation to particular search terms only.
So,
troubles me is the point that I've already raised in relation to the transfer of business and so on. What you told me earlier was that was all over by December 2014 in any event. I understood that right.
Yes, the process of, well, on our case, the scheme and
the
application
onboarding
of it is done by 2014, and for that reason, for instance, relationship managers' documents are not being searched by D5 past December 2014. So the other searches in the case proceed on the basis that all of that ended by the end of 2014.
Yes, Mr. Conte.
You have my points earlier about the general base, but I mean, our approach is much more calibrated. Can I ask your lordship, please, to turn up 7433? That's the table that the claimant's table that we extended. So if you look at item 22, it's for the search term credit or loan and default. And you see we've put a counter proposal, but then because the hit rate was disproportionate, or it was potentially disproportionate, we've agreed to limit. And this has been the general approach we've taken throughout, and we've suggested a date range that brings it down. So we've effectively been driven by the number of hits, because this is a pragmatic metric-driven exercise. If you then move over a couple of pages and look at 7435, you will see that when it comes to the search CRM with a star, again, threw up 1,324 hits. Claimant said it was disproportionate. So if you look at the defendant's request, again, limited the date range to February 2014 to October 14. What they haven't done, or what we haven't done, if you look down at 28, is returns 217 hits. And so again, we propose a revised search string because we're responding to the arguments made by the claimants, but we haven't inserted a revised date range because we're driven by the metrics. And so this is, my learned friend Elie Skeleton cites the authorities, and we don't need to go to them, but disclosure is a pragmatic process. It's driven to get, it's just driven to get the relevant information before the court, but the overriding consideration is proportionality. And so my learned friend in this table, and even his revised proposal, they fight every point. 7 hits, let's have a debate. 0 hits, they want to have a debate. I find that nonsensical, but I'll leave that there. So my point here is we've been very careful. It has been an incredibly careful approach to the date range, because you've heard my reasons for why we say it should be what it should be as a first port of call, but we're driven by the metrics. Where the metrics denote that there are a high number of hits, we're being reasonable, so we're limiting it to a more truncated date range in order to make the search reasonable and proportionate, because that's what this is. This is a pragmatic process.
I think all those points simply show that the date range that the defendants are interested in falls before the end of 2014, because those were the terms that my learned friend showed you.
I'm with you on that, Mr. Sampson. The update range for Mr. Walia expires December 14.
I'm grateful.
End of December.
I'm very grateful, Your Honour. All right. Well, that's the custodial keywords that we had hoped to deal with, but we'll have to pick that up with the defendants in due course. I'm going to move away from that topic. There is, however, the question of non-custodial keywords. Now, the position on this is that the claimant sent keywords for their non-custodial review to the defendants on the 5th of November 2024. So that was before the last hearing. If Your Honour wants to see that letter, it's at 4484.
Not particularly.
Well,
I mean, unless you need to.
It's there, but then 4486 is the list of the keywords.
Right. Sorry, give me the number again.
4486.
Thank you.
And I'm not going to ask you to read this in any great detail, but it is based on the keywords that the parties have been discussing at length for a long time, but structured in a way that doesn't sort of tie it down to communications that pass between certain people. We say that it gives adequate coverage to all of the issues in the case, and we said, and we spent a lot of time looking at the schedule for the custodial keywords at the last hearing, and Your Honour was satisfied that they've been put forward in good faith and for good reasons. And there's been no submission from the other side that we've simply left out relevant areas of the case. The arguments are all about particular keywords and whether they're proportionate or not, and the number of hits. But there's no suggestion that there's just no coverage of a particular issue. It's just how you capture the sentiment. And so we say that that's also true here. And that's illustrated by the lack of a response that we received from the other side in relation to this list. So as I say, it was sent to them on the 5th of November. And then we won't turn up the correspondence, but the response from the defendants on the 19th of November, so 2 weeks later, was that the defendants do not agree with the proposed approach set out in your email, i.e. the list, and do not consider the proposed search terms in your letter to be fit for purpose. And that was it. There was no particularization of why they weren't fit for purpose. And then on the 22nd of November, there was a further letter, which I mean, I'll show you on that one just so that Your Honour can see the level of detail. It's at 6809. It's a 3-page letter. And it's paragraph 1.3, really, that are the objections.
Yeah.
And paragraph 2.1. So the objections are really that we sort of didn't give them a detailed methodology for how the keywords would be searched. But I mean, they get searched through the platform. Everybody knows that. And then in paragraph 2.1, they sort of make points about different categories of documents and simply say, well, they don't know if there would be hits or not. They refer to some correspondence from the liquidator's investigation files. And then they suggest that some of the terms are excessively specific, although the general approach that the parties have been trying to adopt is to come up with specific keywords to limit the ambit of the searches. So we don't think that's a particularly convincing point. And then the third point, they make the methodology point again. But I mean, it's quite simple. You simply run the search terms against the database of documents, and then what's relevant will get picked up. So
I'm sorry, Mr. Sampson. I should perhaps have looked at the letter of the 5th of November, but these keywords were intended to refer to both claimants and defendants' documents?
No, just the claimant's own documents. We made a proposal in respect of our own documents because we wanted to get on with our searches.
Sorry, yeah.
And so those were the keywords we proposed to apply to our own documents, and they've sort of been hanging there. And at the moment, the position from the defendants is that they're sort of taking quite generalized objections, but they haven't come back to us with any comments. And my submission is simply this: they've had plenty of time to do that. The parties should be able to get on with their exercise. I mean, the claimants are going to go away from this hearing and won't be able to do that because of the position on custodial keywords. But at least let's have resolution on the defendants, on the non-custodial keywords. If these are the objections that have been articulated so in the time that's been available, we say, it doesn't really suggest that the keywords are not fit for purpose. The defendants have had their opportunity, and they haven't come up with any specific counter proposals for things that they want us to do. And we take from that that they don't really have serious objections to our keywords, and we should be allowed to use them.
Can I just go back to the keywords document 4486, was it?
That was it.
My lord, the actual document is 4488.
No, the list of keywords is 4486.
So I have a different bundle then. Sorry, mine's 4488.
4488 is a schedule that was produced by Ankura to show hits.
Apologies, you're right. Sorry.
Yes. So I mean, we can look at that. I mean, the searchable population is 11,500 documents, and when applied to that, the keywords produce 4,763 documents. So we haven't come up with some keywords that just produce no documents. We say that we're taking a reasonable approach. This is a serious way of searching the non-custodial documents. And the point in the letter from James Day that we hadn't picked up some letters from Norton Rose, those are letters that were sent in the course of the liquidators' investigations. And the position is that we're going to look at the liquidators' investigative files. We're going to deduplicate the data room against what's in the servers. But I'm not going to press today that we be allowed to apply these keywords in relation to the investigative papers because of this point that the defendants have come up with, that we didn't capture some correspondence that was exchanged in the period of the investigation. We'll look at how we can look at the investigative papers. So for today, I'm asking that we be permitted to search the non-custodial files on the first claimant servers and hard drives by reference to these keywords. So we're talking about contemporaneous documents rather than the investigative papers. In my submission, that meets the point that was made that we hadn't captured documents that the defendants felt were relevant.
I take it that I'm looking at 4486. The first list of names are all RMs, are they?
Yes, so we'd look at their HR files manually because
Yep.
that will contain material relevant to their resignation.
Yeah. Yeah, well, what do you say, Mr. Conte?
So, my lord, I can summarise the position hopefully very briefly. So the first point my learned friend made was about methodology and why it's important. The claimants haven't identified their process that they used to determine whether a document's non-custodial. So I'm instructed there's various processes you could use, for example, reviewing metadata or just making assumptions that all documents on a shared drive that don't belong to a custodian are deemed non-custodial. The reason why that's important, I'm told, is that has an impact on assessing the proposed keywords. For example, you might take a different approach if the documents are mostly Excel files to if they're client account documents. But the more important point is about the not fit for purpose. And I have 3 points here. The first point is that it's quite clear that what the claimants have done is copied and pasted some of the keywords with minor amendments from their custodial keywords lists. And our position is that the fact that documents are non-custodial in nature means you should be undertaking a different enterprise when identifying keywords. Essentially, you don't have the actual custodian in view when you're setting out the keywords. You need to apply your mind independently for the fact that these keywords, the relevant keywords, have to be applied across documents of a particular type or possibly that have been amended by several people that aren't custodians, and that's an independent enterprise. The second point, and this is quite important, the proposed keywords are too specific and inappropriate. So one example that is given in my instructing solicitor's letter is they've selected bonus submission, and we say, well, that will obviously exclude documents which are only shorthand, which is a shorthand variation of bonus submission, so simply bonus. They've also selected shell company. That'll exclude documents that simply refer to shell co or even shell. But ultimately, the biggest concern is about metrics, and it's about that the search terms aren't appropriately calibrated to the material to be searched, and you can see that by the number of hits. Can I ask your lordship to turn up the page 4488, and you'll have to blow it up, I'm afraid, because it's one of Ancura's tables. It's quite small print.
4488. Yeah.
Indeed, my lord.
Yeah.
So my understanding is this is the table that Ancura, the claimant's e-disclosure provider, produced based on running the keywords. So essentially the claimant suggests 51 search strings. Of those, 19 of them, being 37%, return less than 23 hits. So that's nearly 40% of the string, of the strings return less than 25 hits, and 9 of them produce 0 hits.
Yes.
And so it's not only worrying that it's a de minimis number of hits, but they're also concerned that some of the terms that you would have thought would bring back a moderate or significant number of hits don't actually bring back very many at all. So bonus submission or HR spreadsheets, which are in the list. HR spreadsheets 0, bonus submission 0, and they're quite important topics, and we don't have any documents. So when my learned friend makes a submission in his skeleton, and he repeated orally, that the claimant's proposals give fair coverage to the issues in the case, not sure about that, but even if you accept that they did, which I don't think we do, the metrics don't lie, and the metrics show that for whatever reason they're not appropriate. Obviously, the claimants know what documents they have, and they say, well, it's on the defendants to tinker with the keywords. But that's why we asked, how did you make your decisions, and what is the body that we're trying to run keywords for? So if my learned friend's happy to put us in a position where they describe what documents we're dealing with, what the methodology is, then we can engage in the process. But the response from my solicitors in correspondence was, well, have another go at formulating the keywords, or tell us what the methodology is and tell us what documents we're dealing with, and we can engage. But ultimately, this is something that should be dealt with in correspondence by them just simply providing more information of one kind or the other.
Well, I'm not sure I can understand that point, Mr. Conte. I mean, anything that's not custodial is non-custodial.
That is one way you could do it, by making assumptions. Another way you could do it is by looking at the metadata on the document, I'm told. So you look at what the metadata is in terms of author and you decide on that basis. But even then, even if you have that, the assumption for methodology, the type of document, I'm told, makes a difference. Excel versus client accounts versus other documents, the type in play is quite important. And so again, you look at the position for the claimants, for the defendants, there will be an independent exercise of deciding what terms are appropriate for Hypersuite versus what terms are appropriate for the audio recordings. I mean, we all know in common parlance, different language is used than in a formal document. So you need to apply a different methodology and wear a different hat. And so this is not a situation where you say, okay, we're thinking about person X and therefore we know their role, we know their usual language, we can tailor the keywords to that particular person and their role. This is a different enterprise. And we say, well, they haven't actually turned their mind to that. This letter from memory was received very late in the day before the last hearing. And my learned friend takes the point, well, we haven't had a response. I don't need to go through what we've been doing in the interim because my learned leader took your lordship through it in some detail. The point is, we have been very, very busy and we have responded when we can. But ultimately, my very short submission on this is it's just not a really helpful starting point, and there should be some more dialogue. And then, of course, the parties can be cooperative and work up a list. But I don't really see how this list is fit for purpose and does the job.
Samson?
Your Honour, there are no. Mr. Conte sort of asserts that it's not fit for purpose, but he doesn't really identify any particular gaps. He's just trying to identify ways in which he can challenge the exercise. But ultimately, as we said yesterday, it's the solicitor in charge of the exercise who has to take a view on whether it's reasonable. And we say that these keywords are based on keywords that parties have been discussing, which the parties have accepted are relevant to the substantive issues in the case. So the copy and paste argument is misconceived in my submission. The concern about metrics is also misplaced because, as I've said, it's quite a small repository of documents, 11,500 documents, but we're going to search 4,763 of them on the basis of these keywords. So we are capturing a large proportion of these documents, and that tells us that these are not unreasonable keywords. And the related point, which addresses what my learned friend was saying about spreadsheets and the bonus submissions, is that these are documents which are non-custodial, i.e. they don't belong to particular custodians on the shared files of the company. But we have tried to pick up sort of loose items that relate to bonuses, because that's one of the categories of confidential information at the heart of the case. But Ms. Ahmad, who is an agreed custodian and for whom there will be extensive searches, was the HR manager. And if we were to go back to the contemporaneous correspondence, we would see that she was the person who dealt with bonus proposals and submissions and who sent them to D4, particular individuals in D4 for approval in order for bonuses to be given to the relationship managers and other staff of the company. So that sort of documentation is going to reside with Ms. Ahmad as the HR manager in the company. And we have tried to pick up any kind of loose items through searching quite generally for bonus submission, because those are the sorts of documents she would send to D4. She'd send them emails with her bonus submission, and then they would approve it or not. HR spreadsheets, again, if there are human resources spreadsheets, we've tried to capture those, but there aren't any, it seems. We have captured, you'll see a bit further down, there's an item called MIS and .x LSX. So we're trying to capture particular types of spreadsheets that were in circulation within BSAME and which are material to the case because they show what relationship managers' performance was. And there are 55 of those as loose files. So we have picked those up through our proposed searches. Your Honour will know that non-custodial documents which are loose will sort of tend to be things like letters or reports or kind of project documents. And so necessarily you sort of capture them with relatively wide terms. So I mean, we've got, for instance, Badertscher, which is 1, 2, 3, 4, 5 lines down. They were the lawyers who acted in relation to the insurance claim that was made in connection with the liability in the Carafi proceedings, and obviously part of the case is that the company didn't have adequate insurance cover. And it's simply the case that no documents have been picked up. So that means that there isn't any non-custodial lawyers' correspondence in relation to that issue. And then at the bottom of the page, because the insurer was Zurich, we've looked for documents that mention the Zurich Insurance Company, and there is one document. And what we take from that is that there aren't very many such documents that are lying around loose. They're probably in the custodial documents, because we're searching that term against the custodians as well. So we say that we've taken a reasonable approach. We have picked up nearly 5,000 documents by doing this, and we say that on a review of these keywords, they do cover all the aspects of the case, and it's not suggested otherwise. So we should at least have approval for those so that we can carry on with the non-custodial review.
With you on that, Mr. Sampson. It seems to me there's nothing wrong with this list. It's perfectly obvious what non-custodial documents are, given the fact that a small repository, the Ancura figures make sense and gives rise to a good number of documents that are going to be caught by it. I don't see anything wrong at all. Indeed, it seems to me to make sense to take the starting point as the terms which had been agreed for custodial documents, so that I'm going to prove this list as it currently stands.
I'm very grateful, Your Honour. You'll be pleased to know that brings us to the end of keywords for today.
All right. I should perhaps have added that I think the defendants have had more than an adequate opportunity to come back and make suggestions in relation to the keywords. If they had come back and said something and had points to make about the detail of it, then obviously I'd have taken that into account. But as they haven't, this will do.
Thank you.
All right.
My lord, if this might be a good time to break, it's simply for the transcribers, and my learned leader will take the next point so we can do a quick cast swap, as it were.
Yes, very good. That makes sense. Thank you very much, Mr. Conte.
Thank you very much, my lord. I'm very grateful.
We'll take 10 minutes, please. Yes. Well, that didn't prove to be as short as we might have hoped, but there we are. We've made some progress, albeit not as much as one might have hoped. Yes. Where do we go next?
Well, I'm hoping that we're on the final furlong. I wanted to address you about Mr. Gribby's evidence and the matter that you looked at the last hearing, CMC 3. Now, your lordship may recall that at that hearing, Mr. Sampson took you through the allegations of dishonesty in relation to Mr. Gribby. And this relates to the financial statements that were produced by Deloitte, sent to Mr. Rajiv Philip, who is the compliance officer, for comment. He didn't have any comments. And Mr. Gribby then provided changes, and Mr. Gribby's changes to the financial statements were that he crossed out the statement that management had decided to cease the business. He crossed out the statement that management had decided to transfer the book of business and employees to other group affiliates, and it was replaced with management has decided to cease the business of the company. And although it has been contended that that was a typographical correction, it isn't. It was a complete recharacterization of what happened. And we rely on that as part of our case of dishonesty. And we say it was an attempt by him to falsify the record. Now, the defendants didn't, when they put together their original disclosure proposals after you ordered disclosure at CMC 1, they did not accept that Mr. Gribby was even needed to be a custodian. And that was something that we had to fight for before it was conceded the day before CMC 1. But we say that Mr. Gribby is obviously a key protagonist in this matter. He's likely to be a witness. In fact, the impression given by my learned friend Skeleton is that Mr. Gribby was one of the 4 witnesses that he identified who had already given evidence in this matter, and then he went on to say another 8 might give evidence, and that formed part of my learned friend's 12 witnesses. So our understanding is that they have a firm eye on calling Mr. Gribby, and rightly so. But we say that because of the nature of the allegation against him, particularly it relates to interference with records, it is important that he is not supervising, running, overseeing this disclosure process. Now, it's a point we've been pushing on for some time, but it's a matter that the defendants have resisted. And we wrote on this topic on the 28th of October, and that's at 3506 of your bundle. We said there, did your lordship have that?
Oh, yeah. Yeah.
And we said at paragraph 19, we referred to our previous letter, and we said we explained there why it was inappropriate for Mr. Gribby to be involved in strategy, operation, or supervision of the 4th or 5th defendant's disclosure exercises. We referred to their response, in which they essentially pushed back, and they said if Mr. Gribby were to provide instructions to any custodian regarding the disclosure exercise, that would be perfectly proper. That was their position. And Mr. Gribby is the 2nd most senior lawyer at BGSS, and he would be providing those instructions at our firm's request. And we said, well, we were obviously concerned about that. We said it went against best practice. We said that in large organisations, there ought to be a framework for disclosure, and so not reliant on any one individual. And then at 21C, we referred to this allegation of dishonesty about Mr. Gribby, and said that he would be expected to be a witness and not independent. And so we asked at 22 for the defendants to confirm whether Mr. Gribby was giving instructions to the individual defendants or any other custodians in respect of the disclosure of their documents. And I just want to focus, it's on the any other custodians in particular that I'm examining today. So that was, we asked for that confirmation. It was a straightforward question, but Jones Day repeatedly ducked that question, and we didn't get an answer to it. So the matter then came up at the hearing before you at CMC 3 on the 6th of November, and Mr. Sampson addressed you on it. And if I go then to essentially what your lordship found, having heard those submissions, that's in the transcript at page 6710. And we were seeking in our draft order orders against Mr. Gribby and in relation to Mr. Carton, and it's only Mr. Gribby that we're concerned with here. You refer in the first sentence to the orders that we're seeking. You say in the second sentence, one of those orders is against Mr. Gribby, the other is against the third defendant, Mr. Carton. Both are accused of dishonesty in one way or other in the particular claim that have been served. It is clear to me, so far as Mr. Gribby is concerned, he should not be involved in the disclosure exercise in terms of giving instructions as to what should and should not be the subject of disclosure. It is clear to me that he should not be involved in any way in contacting others who are being asked to give disclosure. In those circumstances, as there is ground for suspicion that he might have been so involved, it is necessary for the court to take some action to ensure the integrity of disclosure. You then go on to deal with the jurisdiction, and then at the next page, finding that you do have jurisdiction to make this order, you say at 611, in those circumstances, both under the terms of 2814 and as part of its inherent jurisdiction, this court can make an order of the kind sought against Mr. Gribby, and in this case thinks that it is appropriate to do so. The form of the order is unobjectionable in light of what I've said, and I therefore make an order in the terms of paragraph 8 of the draft order. And if I could then take you to actually the form of that order, that is at 7412.
Just bear with me a moment.
Of course.
7418, did you say?
7412.
Yeah.
And the order is now in paragraph 16. And your lordship required the defendant to serve, fourth defendant serve a witness statement from Mr. Gribby setting out whether he's been communicating with the defendant's custodians in relation to disclosure in these proceedings without Jones Day being party to such communications. If so, when and how such communications take place. And then finally, whether those communications related to the deletion, alteration or withholding of documents.
Yes.
So that was the order that you required. And you ordered that to be provided by sometime last week, and we got a witness statement from Mr. Gribby last week. I know your lordship has read that because you mentioned that yesterday, and that's at 5124.
Yeah.
And at paragraph 2 of that statement, Mr. Gribby sets out the order that your lordship has made. He doesn't actually refer to the part of the transcript I just showed you where your lordship explained clearly that Mr. Gribby should not be involved in the disclosure exercise in terms of giving instructions, etc. But I'll come back to that point.
I didn't actually make an order in those terms, did I?
You didn't, and that is an issue that I wanted to grapple with today because that actually now may be important. I mean, my submission on that is that you didn't need to. Your lordship, what your lordship said was clear, and your lordship's intention was clear. But it wasn't recorded in the form of the order, and we will come to that in a moment as to whether that's appropriate. But before we get there, at paragraph 2, Mr. Gribby sets out the order that your lordship made. And at 2.1, I mean, he's slightly changed the language, but it's if anything, it's sort of clearer what we're talking about. At 2.1, he says he has to set out whether I had been communicating with the defendant's custodians in relation to disclosure in these proceedings. So it's quite clear that he's being asked to set out the historical position. And he's also required, if there was communications, he needs to particularize when and how such communications took place, and then also essentially the nature of them. So that is clear that Mr. Gribby and the defendants understood what your lordship had ordered. Now, in relation to I'll pick up the fifth defendant first. So his evidence on the fifth defendant is at paragraph 16 at 5127.
Yes.
And there he does answer your lordship's questions. So he says, I've had no communication with any of the fifth defendant's custodians in respect to the disclosure exercise in these proceedings. But he explains that some emails sent to Mr. Swan concerning disclosure of issues may have been copied to him. Fine. But he then goes on to say that he hadn't given any instructions to Mr. Swan, and he had no discussions with any of the custodians, fifth defendant's custodians, in relation to the deletion, alteration, or withholding of any documents. Yes. So that does address the order in relation to D5. But in relation to D4, if you go back to the previous section, this is section B2, which starts at paragraph 11. He starts there with the position on the 18th of October 2024. So just a few weeks before the statement. And then he gives quite a detailed summary of what seems to have happened between the 18th of October 2024 and the witness statement. But in relation to the position before the 18th of October, all he says is that paragraph 15, in my role as group head of legal, I have regular contact with BGSS's custodians who remain employed at BGSS. But I can confirm that I've never had any discussion with any BGSS custodian as to the deletion, alteration, or withholding of any documents. So he rather elides the issue by saying he doesn't actually address the question of whether he has had contact with custodians in relation to disclosure in these proceedings. That's not addressed at all. He just says, I have contact with these people. And of course, he doesn't then deal with the second part, which is particularizing any communications that have taken place. So unlike the position in relation to the fifth defendant, where a clear answer is given to your lordship's answer order, in relation to the fourth defendant, essentially the point is not answered. And there's a lot of detail given for the period in the last few weeks, but nothing said about the previous 2 to 3 years. And we don't know exactly what Mr. Gribby was doing over that period, but after Mr. Astruct, he is the second most senior legal person at the defendants. And we do know that he has had very senior level involvement in disclosure at various stages. So, for example, at 3467, which is a letter from Jones Day talking about this issue. I mean, this letter is actually talking about when Mr. Gribby became aware of essentially the nature of disclosure obligations in this type of litigation. Does your lordship have that?
Yeah.
So this is a letter from Jones Day, 3467, paragraph 10.16. And then in the last sentence, it says, as you correctly identify, Mr. Gribby discussed retained documents of the fifth defendant after receipt of the letters before action. And those letters before action, as your lordship will recall, are from early 2022. So he obviously was involved in discussions about documents of D5 in 2022. That's not surprising given his senior position in the group. And we also know that in relation to 2024, if you go to 1264,
Yeah.
this is an email from Mr. Gribby to, I think, the head of data at the defendants, and this is in relation to, I think, document retention or straight destruction processes. And this is January 2024. So again, evidence that Mr. Gribby is involved in discussions at a senior level about disclosure. I think we don't have the contents of it because there was a concern about Swiss law of confidentiality. So as I understand it, we don't have all the material for that. But you can see it's an email from Mr. Gribby to the head of data, and apparently there was an attachment about some blocking of, I think, certain client data that about whether it would be destroyed or not. And sorry, there's one other point, my lord, which is that if you go to 1595, this is the engagement letter from EY engaging their services for the defendants, looking to appoint them as the discovery provider. And this is the 23rd of September 2024, and it's Mr. Gribby. It's written to him. He's the client. He's the person who's instructing EY. Thank you for choosing EY in the first sentence.
Yeah.
So I point out these documents to show that one would expect Mr. Gribby to have had some involvement with disclosure custodians prior to the 18th of October, which is the first event mentioned in his witness statement. None of that is spelt out in his evidence. Our understanding is that is what your lordship requires in his evidence. And my lord, that takes me on to the next point, which is that I took you to the passage of what your lordship said in terms of Mr. Gribby not being involved in the exercise. If we go back to his witness statement at 5124, And we can go forward now to page 5128, paragraph 18. Now, in this section, Mr. Gribby really deals with the point that I took you to in the transcript. He says that James Day have informed me that the claimants have suggested that I should be excluded from the defendant's disclosure exercise. And then he goes essentially on to explain why that should be resisted. And I just want to look at his explanations. But nowhere here or anywhere in the statement does he refer to what your lordship had already said in the transcript. And essentially this part of the statement is designed to persuade the reader that in fact there's good reason for him to continue to have heavy involvement. And he spells that out in the following paragraphs. We'll start with 19. So he says his reasons are, first of all, he's group head of legal, effectively the second most senior person in the legal department. Of course, the most senior person is Mr. Astruct. And he says he sits in Basel and provides leadership to the legal team in that office. So, I mean, geographically, he's got an importance as well with the Basel team. His second point is that he's the only legacy Saracen lawyer remaining at BGSS who worked on corporate issues related to BSA. But that's not a point in his favour. That just highlights that he's a witness in this matter. And we know that. We know that he was involved in the corporate issues. That's why he's referred to in the pleadings. And then his third point at 19.3 is that as a very senior lawyer in the organisation, he says he's fostered long-standing relationships that enable him to obtain the cooperation of employees who might otherwise be hesitant to share information. He says many employees who ask to cooperate in such exercise are extremely reluctant to do so. And then finally, at the end, he says obtaining the cooperation of employees of a Swiss bank in such an exercise requires a strong relationship of trust. I've developed such a relationship with many BGSS employees. So it sort of contrary to your lordship's direction in the last hearing about trying to keep him away from the custodians, his argument seems to be that he's the man to be in there trying to persuade these custodians to cooperate. And then he develops that at 20. He says his source of special institution knowledge for BGSS. I don't dispute that. And of course, he is a resource when it comes to getting information about how the entity operates and how an entity operated at the time. But that isn't a reason for him to be supervising or running the disclosure process. And then his second point at 20.2 is really the same one as 19.3. He's able to assist in securing the cooperation of employees who might otherwise be hesitant to take part. And then he goes on at 21 to say excluding him from the disclosure exercise would greatly prejudice the fourth defendant's ability to defend the claim. Now, just pausing on that for a moment. We don't accept that. I'm not suggesting for a moment that they can't draw on him as a repository of information in making sure that they're running a proper exercise. That would be part of the due diligence in disclosure, speaking to relevant witnesses and contemporaneous custodians. But it is quite different getting that information to having that person supervising or taking the lead at the organisation for the exercise. And that point really is highlighted at paragraph 22, where he sets out actually what he does as a matter of governance. And he says in the second sentence, in line with JSSH's legal and compliance directive, I provide quarterly update reports on all litigation matters to the board of directors of both the fourth defendants and its parent, and the fourth defendants risk committee. Furthermore, the information regarding litigatory matters also forms the basis of quarterly report on litigation to FINMA. I'm also responsible for preparing the fourth defendant's legal budget. And he says if he was excluded from the disclosure process, he would not be able to discharge these duties properly. And that in turn would prejudice the fourth defendant's ability to function effectively. Now, my lord, we say these are very surprising functions for an individual who is accused of dishonesty in litigation to be doing, to be the person reporting to the board, to the risk committee, to the financial regulator. And in our experience, in any other entity, business entity, individuals who are accused of dishonesty in ongoing litigation would be excluded from the governance process rather than being at the heart of it, because that is good governance. So we think that none of those points are good reasons for the to resist the order that we seek. If anything, the order that we seek would put the fourth defendant to a position of good practice, where its current practice seems to go against every principle set out in the company law textbooks. So, my lord, that brings me to the order that we seek today. And really what we're trying to do is embody in the order what your lordship said at the last hearing. And I'll take you to that draft order. Is it 6927? And we're seeking an order both in relation to Mr. Astract and Mr. Gribby, because they are the two most senior people in this organisation. They're both accused of dishonesty. It is troubling that they have any involvement in the decision making or giving of instructions in relation to disclosure. I'm not looking to exclude them from the whole process in its entirety. They can, of course, provide information. They must be allowed to do that. But I want to focus only on the decision making or giving of instructions. And on that, we say that neither of them should be involved. And the order that I'm seeking, we say, reflects what your lordship said at CMC3 in relation to Mr. Gribby, which was that he should not be involved in the disclosure exercise in terms of giving instructions as to what should and should not be the subject of disclosure. And you also said it's clear to me that he should not be involved in any way in contacting others who are being asked to give disclosure. So, my lord, that's...
Well, there's a difference there between what you're seeking and contacting others, which is what he says he's been doing.
Yes.
To effect introductions to Jones Day. You're not seeking an order that he should be prevented from approaching an individual to say that they should be cooperating with Jones Day in the disclosure exercise.
So if that happens with Jones Day present, then I have no objection to that, because obviously we have great faith in Jones Day. But that sort of discussion shouldn't be happening privately. It is just too fraught with difficulty for an individual who is accused of dishonesty in these proceedings and is very senior. I mean, that's part of the poison. One can imagine, my lord, working in a bank, I did many years ago, where a very senior member of management comes and asks you to do something or not to do something. It's extremely difficult to resist. And so you can see the challenge when Mr. Gribby is calling the shots on the exercise, is the second most senior person in the department, and also holds all of the lines of key communication to the board, to the risk committee, even to the regulator itself. So at this stage, the order we're seeking is only in relation to the decision making or giving of instructions.
Well, I'm looking, for example, at paragraph 14 of his witness statement and his contact with someone like Mr. Dupont.
Yes.
Now, what he does there, he says that he called Mr. Dupont and effectively told him that a disclosure exercise was going on and asked about arranging a call with Jones Day. And indeed, the essence of what he appears to be saying in paragraph 19.3 and 20.2 is that he has a role to play in persuading people to cooperate in a disclosure exercise with Jones Day in the face of potential Swiss secrecy laws and the like. And the question I'm asking you is whether you are seeking some form of order that he should or should not do such things. I mean, what I expressed at the last hearing was expressed in wide terms about involvement in contacting other people at all. But of course, that was expressed in wide terms without knowledge of any of the matters that are referred to in his witness statement.
So it is a concern to have someone in Mr. Gribby's position making these phone calls without any record of what is being said, speaking to all of the key custodians, some of whom might be part of my learned friend's 12 witnesses. So I do have some concern about that. I mean, it's a matter of your lordship how far you want to go. I'm not trying to hold your lordship to the language you expressed at CMC3. I totally understand. It was a broad statement of principle, not intended to be a precise bit of drafting. But as you, that's one matter for your lordship to decide. I mean, I think
in the ordinary way, what I said would go. I mean, that would be it. One wouldn't have contemplated any need for him to be involved. But what seems to be suggested is that there is a potential need. Whether that's well founded, I have no idea.
It's quite difficult to probe that too deeply. But ordinarily, I mean, just one general point is, and your lordship's probably come across this from practice, but within banks there are. I mean, legal is an ancillary function. There is the main business, the business supervising structure, and then legal sits inside, compliance sometimes sits on the side as well. Mr. Gribby is not these people's line manager, and ordinarily you would expect the line manager to ring up and say, the business needs you to do something, we're involved in litigation, we need your documents, or we need you to give a witness statement. So I don't see any particular reason why it's Mr. Gribby who's got that special relationship with these employees, and that's the magic connection which allows him to unlock these witnesses. We think that's far-fetched. I mean, the reality is that there'll be lots of strong relationships within the bank between staff, and other people could make these approaches. But even if it was a necessity for Mr. Gribby to be the person reaching out because he was the only person who had a good relationship with that individual, that contact would need to be subject to supervision because it is so heavily open to abuse. I mean, obviously, because he's accused of dishonesty and actually changing the record. So we do think that. So that's one piece. That we say that's very unsatisfactory. I'm in your lordship's hands as to how you want to deal with that. But I'm not saying that you should be held to the wording necessarily of what you said last time, although we did rather feel that it was clear what your lordship meant. So that's the first point. The second point is the decision-making or supervision, which is the order that I'm seeking.
Yeah.
And actually, there's nothing in Mr. Gribby's evidence that suggests that it would be problematic for the defendants if he was excluded from decision-making or giving instructions. And then the third piece is the fact that his evidence does seem to be incomplete in relation to the position prior to October 2024. And your lordship doesn't need to make a further order on that. You've made an order on that. But if your lordship could give some words of encouragement for the defendants just to go back and look at that evidence and consider whether it genuinely is comprehensive and complete, and perhaps file an updated statement, that would be helpful. So those are my points, my lord. Are there any questions I can help you with?
No, thank you. Mr. Montague-Smith.
Well, my lord, just to put this in context, so this is an issue which was raised on Sunday night, and it found its way into the skeleton argument in 2 paragraphs of the skeleton argument. The main complaint at paragraph 103 of the skeleton argument was that if one looks at Mr. Gribby's witness statement, it indicates that he has or intends to breach or take action which conflicted with the guidance you gave at the last hearing. I will deal with that, but this is not. There's no application that has been made for this. There's no evidence which is provided for this, and there is no opportunity to provide evidence in response. My learned friend then makes his submissions today. What does he do? He makes serious allegations that my client have breached the terms of the order that was made against them by not providing information in the witness statement which was ordered. In fact, that is wrong. I can deal with it to some extent, but then what my learned friend does is in completely unheralded submissions, which have never been in any way foreshadowed, he takes you to various discrete documents in the bundle, which he says indicate that there was other contact which would have fallen within the terms of the order and which should have been disclosed in the witness statement. So I've been scrabbling around trying to take instructions on those particular documents while my learned friend's been speaking, so that I can also listen to him, listen to your lordship's intervention, and also try to come up with an answer to explain the documents that my learned friend has for the very first time told you about, and said that they raise terribly important and serious questions about conduct on behalf of my clients. This is, with great respect, absolutely no way to advance these sorts of allegations against serious allegations against a bank in these sorts of contexts. It is not, with respect, acceptable. And then towards the end of my learned friend's submissions, he shifts away from the narrow terms of the orders that he was actually said to be seeking, and for the very first time appeared to give some indication that he wants some sort of order requiring basically ordering Mr. Gribby not to have contact, perhaps confined to certain parameters, who knows, with 54 custodians, some of whom remain people at the bank. This is an ongoing commercial enterprise of which he is the bank, the group general counsel, and the idea that he shouldn't have contact with those individuals, and that your lordship should be considering.
Hold on, Mr. Montague-Smith. That's not what's being sought in paragraph 10 of the draft order.
I know, that's right, but my learned friend picked up on your lordship's suggestion. Well, what about contact? And he said, oh well, maybe we'll have one of those as well. So it's a rolling.
That's my issue, Mr. Montague-Smith. It's no good blaming Mr. Shivji for that. I mean,
well, let me deal with that
regardless
question.
of the rights or wrongs, as soon as one gets allegations of this kind, it's very unwise for anybody to do anything that could possibly lead to a finger of suspicion being pointed at him. And when I made what might be thought to be an off-the-cuff comment, but it wasn't off the cuff, but it was broad in its terms, I simply didn't envisage that there'd be any problem. I just thought it's obvious he shouldn't be involved in the disclosure exercise, full stop.
Well, but what does that mean? So my learned friend, what does it mean to take instructions? What does it mean to be involved? So that's the point. What my learned friend is saying is, if you read Mr. Grieby's witness statement, what that indicates is that somehow he wants to do things which would be in conflict with the orders that he seeks. So he is suggesting that if a fair reading of Mr. Gribby's statement is that he wants to supervise the strategy or operation of the disclosure exercises. He says nothing of the kind, and we can go through that. It's absolutely not what he says. So,
well, I accept all of that, Mr. Montague.
So then why on earth do we need an order? We have what your lordship has said. Now, apart from these allegations that Mr. Gribby hasn't complied with the terms of the order that was made against him, which I can try and deal with, what have you got? You've just got the terms of Mr. Gribby's witness statement. And what does he say? So let's look at it. It's 5126. It's the relevant passages.
Yeah.
Paragraph 11. He explains what he has done and onwards in relation to the fourth defendant's custodians and the contact that he's had with them in relation to the disclosure exercise. My learned friend says, well, if you look at paragraph 15, it's not clear whether he's actually given you that information. That is, with respect, nonsense, because that is what he's doing in paragraphs 11 to 14. That is not a respectable submission, certainly not one to make in this unheralded way. It's quite a serious allegation. And it's redolent of the way that these sorts of allegations are being bandied about in the course of hearings like this. It's not, with respect, the way to do things. Paragraph 11, he explains what he has done to try to facilitate these. Now, this all comes before your Lordship's observations. If your Lordship wants to make it clear subsequently at a later date that this sort of conduct is out, well, A, this has all happened. B, the data is in, the documents are in. That there are a few hard copy documents left with the forced defendant, which have been identified and which are being scanned and uploaded. But the evidence, and we've been over this all yesterday, what more is there to do? Well, the concern that my learned friend says he has is that there's going to be some sort of interference in the process going forwards. Well, what is that going to be precisely? But let's go back to, he doesn't say, but let's go back to paragraph 12. So he identifies, he's providing information at this stage. He's helping to find the documents because there are custodians who are no longer employees, and he's trying to help parties find the documents with the bank, which will fall within those custodians' parameters or within their custody, would have fallen within their custody when they were at the bank. And so he's arranging interviews with employees. And in those circumstances. Now, of course, if you take the view that he's a fundamentally dishonest man, then one might think, well, all right, there's some problem there. But until that's actually been established, then it seems to me that this complaint is entirely overblown. And then paragraph 13, he's talking about escorting people through the building because passes are required. Now, just pause there. My friend's effectively saying, well, he shouldn't have any contact with these people. If he's that dishonest, you're not going to find out about the contact in the first place. But ultimately, unless there's something to doubt his account here, then what he's explained to you in very full and frank terms is the absolute detail of what he's been doing. And as he says, end of paragraph 13, once he's made the introductions, he leaves the meeting. One can totally see why some sort of connection from Mr. Greeby helped to facilitate those sorts of meetings, because people are going to be reluctant, particularly in the context of Swiss banking regulations, particularly in the context of the penalties that can ensue if the individuals get that wrong. So they're going to want to know from their group head of legal, it's fine, you can speak to these people, you can give them what they ask for. Because it's a legal issue which arises for them. What's said in paragraphs 11 to 14 then gives you everything about the contact that he's had with forced defendants, custodians. And then paragraph 15, he makes abundantly clear. Firstly, he has to have some contact with those custodians who are at the forced defendant, not about disclosure, but about the daily business that goes on in banks. And of course, your Lordship's concern is not to interfere with the commercial activities of an ongoing enterprise. It's important to ensure the integrity of this process, but it can't go so far as to interfere with ongoing commercial operations. And then he says this, but I can confirm that I have never had any discussion with any BJSS custodian as to the deletion, alteration or withholding of any documents. So he goes to the heart of it about the BJSS custodians. As to the fifth defendant, no communications with any of their custodians at all, save that some of the emails sent to Mr. Swift concerning disclosure issues may have been copied.
Well, nobody's fussing about D5.
Right, but he goes on to explain about D5 and that he's never done anything anything to do with that. So there is nothing in that suggests that he has ever tried to control disclosure in any meaningful way. And as I say, so the focus really, and this was the focus until my learned friend's submissions, which ranged rather more widely, and bled into allegations that this is not actually a satisfactory response to your Lordship's order. Don't accept that. So, for example, he took you to page 1264, which was an email forwarding on, doing the best I can, as I understand it, that email, page 1264, was in an email which arose in relation to the end-of-year purge of client documentation. And Mr. Greeby was seeking to ensure that all potentially relevant clients were not subject to the deletion. That was an email sent to the head of data, who is not a custodian. So what my learned friend's point is in relation to that document, I do not know, but it demonstrates, my lords, the danger of my learned friend making those sorts of serious allegations on the hoof, and the danger of me trying to answer them on the hoof in circumstances where if he was right, that supported his submission, that would be quite significant and serious to my client. But I don't know what the answer is to the other documentation, because I simply haven't had a chance to look at it. I'm told that Mr. Swan has given a statement which perhaps deals with quite a lot of that sort of stuff, but I'm not prepared to give you a full answer, because I just don't have it in front of me, because I've had no forewarning of it. Someone's trying to give me a note as we speak to help me with it, but I don't think I can give you a comprehensive answer. The question in the skeleton argument that was alleged related to paragraph 18 of the witness statement, where what Mr. Greeby says is, excluding me from the defendant's disclosure exercise would severely prejudice BGS's ability to marshal its evidence in support of its defence, and therefore affects its ability for a fair trial. Now, he's already said that he has not given any instructions about what should or should not be included in disclosure. Your lordship's already made the comment about the fact that he should not be involved in those sorts of decisions. He's quite clearly not saying here, and I want to be able to tell Jones Day, well, there's a swathe of documentation that needs to be excluded, or more to the point, Ernst & Young, that certain search terms shouldn't be included, or something of that nature. But there's no suggestion that he intends to do that, will do that, and one cannot take that from paragraph 18. What he needs to be able to do is provide information. My learned friend says that's perfectly fine. If necessary, facilitate the process. Well, it's difficult to see what there is left in relation to that. But if Mr. Greeby is the one who can say it's fine, employee, you can talk to Jones Day, you can give them the documentation, then what on earth is wrong with that? And the idea that he should be ordered not to have any general contact, because if he does, he might do something wrong, is just A, there's no support in the evidence to it, but B, it doesn't make any sense. Because if he's really that dishonest, he's going to do it anyway. So I mean, what's the point? What's really going on here? And so the other thing that he needs to be able to do is sign the bills. And the approval process for those is simply part of it. There is an authorization chain in the bank, I'm told, of which you have no evidence because we haven't had an opportunity to put anything in. But again, I only have a partial explanation of how that arises, because there isn't a proper application before you, which I've had a chance to answer. So my learned friend's skeleton, actually, paragraph 103, says that the explanation of what Mr. Greeby is proposing to do is inconsistent with the guidance that you gave at the last hearing. And the guidance, the relevant element of that guidance is that he should not be, it's at page 6, 7, 10. He should not be involved in a disclosure exercise in terms of giving instructions as to what should and should not be the subject of disclosure. Now, the contact is a separate thing, but in terms of what my learned friend appears to be applying for, asking you for, is that he should not be giving instructions as to what should and should not be the subject of disclosure. There is nothing whatsoever in his witness statement that suggests he intends to do that. It's quite difficult to see how he could do that without giving instructions to Jones Day or to Ernst & Young about how the process should be conducted. Got the data in, search terms are going to be affected, and then lawyers are going to do the search. What need is there for an order in terms that has been asked for? And in our submission, your lordship gave quite some indulgence last time in making orders requiring witness statements. We accept that decision, but there has to come a point where enough is enough. You're going to make orders in the form of effectively injunctions requiring certain things to be done, then those are serious orders, and they ought to be sought in the proper way. As to Mr. Astruc, well, all that is said is that, well, because there's a problem with Mr. Greeby, of which we dispute, that somehow this can be translated and some sort of line can be drawn to Mr. Astruc. The only document that my learned friend relies on in his skeleton argument is a reference to the transcript, which you'll find at page 2594. And the relevant part is in the second half of that page, probably best place to pick it up. You note that Mr. Astruc is general counsel, but is also one of the defendants. And you say, fourth line down, in those circumstances, it seems to me that he cannot be the person who is responsible for decision making because of the allegations made against him individually. And further down, however, when it comes to disclosure, someone independent from him has to be the person who takes responsibility for decisions. There's simply no material in front of you to suggest that anybody is doing anything outside the terms of that. What's said, the way it's put, actually, in my learned friend's skeleton argument, is rather redolent of the way that these sorts of things have been dealt with by my learned friends along the way. They don't say, there has been a breach and here are the particulars. They don't say even, here are the particulars of the breach that we think that there is real suspicion. What is said is that the issues in relation to Greeby raise the question of whether Mr. Astruc has respected the court's guidance. So there's an implicit allegation of some sort of breach, unparticularized, which isn't even really made as an allegation. It's just, well, there may be a question. Allegations of serious misconduct, which is what that would be, ought to be made properly, ought to be particularised, ought to be supported by evidence. To be clear, there is no evidence, there is no application, and we would say there's no shadow of a need for an order of the sort that is sought from my learned friend. And I remind your lordship again, the contents of those two witness statements from Ms. Howard, the contents of the witness statement from Mr. Vallat, which explain in copious detail what actually has been going on in relation to that. And my learned friend made no submissions that anything had gone wrong in the process. There was no complaint about any of that. And yet somehow there's this nebulous allegation that somehow one or other of Mr. Astruc or Mr. Greeby might have put their hands over it. That would be wholly inconsistent. I mean, it depends on what the allegation is. But we would say, whatever it is, it would be wholly inconsistent with all of that evidence. Quite apart from, as I say, the fact that there is no more to do in that regard, other than get those hard copy documents and complete that process, getting the hypersuite documents are coming across, doing the searches, which will be lawyers, Ernst & Young, doing the review, which will be lawyers. So your lordship has made the observations you made at the last hearing, and that is quite sufficient. If you make an order now, it's obviously going to be relied on by someone later down the line as indicative of some sort of finding or implicit finding that there has or may have been some sort of breach of an order. And one should not, without cogent evidence that there was or may be a breach of an order, make orders of the sort that have been sought by my learned friend.
Well, Mr. Montague-Smith, you have not been your usual succinct self.
Well, I apologise for that, but it's difficult to answer these points when they're brought up in the way that they're brought up, my lord. And these are not benign complaints. These are serious allegations, and they have the risk of just pure prejudice for your lordship. But also for the transcripts and now for the orders that have been made.
All right, thank you. Mr. Shivji?
I will keep it brief. My learned friend was shocked by the 3 documents that I took you to and said he was ambushed. And I know that he wasn't at the hearing CMC3, and he may not have had a chance to have a look at the order and transcript. But 2 of those documents you were taken to.
Yeah,
one of those documents actually is recorded in the recital to the order. So I think his shock probably comes from not having caught up with what happened there. And in relation to the 3rd document, that is actually referenced in our original letter of this, which was the 7th of October, which set all of this up. So, and this is not a new line of inquiry. It's not a new ambush. Of course, the responses to Mr. Gribby's statement came in over the last few days, but that's because we only got the statement 7 days ago. So inevitably, we can only respond to the statement once we've got it. But just taking a step back for a moment, in this case, the 2 most senior legal officers of the bank are accused of dishonesty. That is extremely unusual in litigation, because nearly always the allegations involve the business people, etc. It's very rare to have in-house legal personally implicated in the underlying allegations for the case. And in any normal, it's an area that I know a fair amount about corporate governance. In any normal organisation, individuals accused of fraud, even if they are the most senior management, would be excluded from the particular piece of litigation and the business decisions made in relation to it. That is entirely standard practice across the world in terms of developed organisations. It is astonishing that Mr. Astruct and Mr. Gribby have not stood aside in relation to the running of this disclosure exercise for the 4th defendant. And in fact, it's remarkable that my learned friends are resisting this. If anything, this serves to help Mr. Astruct and Mr. Gribby, because they can say, look, the court has rightly said that we shouldn't be involved in this exercise. That puts us in the clear. This is not part of our managerial responsibility. It can go to others who are genuinely independent. And your lordship has been around this track with us several times. So again, Mr. Montague-Smith won't be familiar with this, but the transcript he took you to from CMC1 was an argument in relation to Mr. Astruct's involvement. And that's because we had exactly the same debate in relation to him. We said it was highly unsatisfactory that he was leading the exercise as the most senior lawyer in the organisation, and he had to be excluded. And that's why your lordship said what you did about him not being involved and it being run by independent people. Now, the order I'm seeking is in relation to the management and supervision of this exercise. I'm not trying to exclude them entirely from the whole process. I'm certainly not trying to cause problems for the business lines. But ultimately, the parties, the court and the public must have confidence in the exercise the defendants are running. If they genuinely want to have the accused wrongdoers in charge of their own disclosure exercise, then that is their lookout. But it is not unreasonable for me in those circumstances to say they should be excluded from managerial control. And then, my lord, the final point is that my learned friend said that Mr. Gribby's evidence was in full and frank terms. I find that a difficult submission to swallow, and he referred you to the passages that dealt with the activity from the 18th of October 2024. But the evidence is not full and frank in relation to the previous 3 years, because it says nothing about what he was doing. And those 3 documents I took you to, which the defendants have had plenty of time to think about, come up with an answer with, show that Mr. Gribby was involved in disclosure at various points over those 3 years. And your lordship has already directed that he should give proper particularisation of his communications with custodians over that period, and he of course should do so. So, my lord, unless I can assist you further, those are my submissions.
Thank you. The claimants seek 2 orders in paragraphs 9 and 10 of their draft order. The first is that the second defendant must not be involved in the decision-making or giving of instructions in relation to the supervision, strategy or operation of the first, third, fourth and fifth defendants' disclosure exercises. The second is that Mr. Greeby should not be involved in the same way in relation to any of the defendants' disclosure exercises. I ordered in the context of suspicions that had been levelled against Mr. Greeby, whether well-founded or otherwise, that he should set out in a witness statement whether he had been communicating with the defendant's custodians in relation to disclosure in this proceedings without Jones Day being party, and if so, to provide details of those communications, when and how they took place, and whether they related to the deletion, alteration or withholding of documents. As a result of that order, Mr. Greeby filed a witness statement dated the 20th of November 2024. It is important to read it in context. At paragraph 10, he says that he sets out the information that the court has required him to provide in paragraph 16 of the order, dealing first with his interactions with the fourth defendant's custodians, and then dealing with the fifth defendant's custodians. So far as the fourth defendant's custodians are concerned, he starts by saying, on or about the 18th of October, Jones Day instructed him to arrange interviews with each of the custodians that the fourth defendant still employs. He then explains how he set about doing that, arranging interviews with the relevant employees, and paragraph 13 describes how Jones Day met with them and how he escorted Jones Day to introduce the individuals concerned before leaving the meeting. He also supplied Jones Day with the last known email addresses of 3 custodians who had already left the employ of the fourth defendants. He concludes that part of the statement by saying that he never had any discussion with any fourth defendant's custodian as to the deletion, alteration or withholding of any documents. Read in context, he appears to be saying that his first contact with any of the custodians in question was on or about the 18th of October 2024. Mr. Shivji complains that nothing is said about the period preceding the 18th of October. It seems to me on the face of it that there is no reason why I should take the view that there has been a withholding of information in relation to what took place prior to the 18th of October 2024. Mr. Greeby says that he is setting out the information that the court has required and begins with events on that date. If, come the trial, Mr. Greeby gives evidence and Mr. Shivji or anyone else wants to cross-examine him on that point, then of course they will be able to do so. So far as the fifth defendants are concerned, no complaint is made in relation to their custodians because paragraph 16 to 17 is accepted, do deal with the points specifically ordered in the order that I previously made. Having said all that, there does remain an issue to be grappled with. The position, to my mind, is pretty clear. There are 2 senior legal officers who are implicated in the underlying allegations that form the substance of this litigation. Good corporate governance does require that they should be excluded from involvement in the disclosure exercise, without in any way suggesting that there is good evidence that they have been interfering with it in any improper way. My view is, as previously expressed on the 6th of November, that they should not be involved. And they should not be involved in any way in contact with others who are being asked to give disclosure. I cannot see that there is anything at all in the points raised by Mr. Greeby at paragraphs 19 onwards as to why he should be involved in this exercise. It is not suggested that there are not other lawyers who can deal with this. Insofar as he may need to report to the board, one would have thought the board would actually want a report from someone else. But insofar as he does need to report to the board, he can do so on the basis of reports given to him by others who are supervising the disclosure exercise. He can do it on the basis of a Jones Day report to him. That would be the logical and obvious way to do it. That likewise would apply in relation to any regulatory compliance and reports that he has to give in that respect. I therefore take the view that he should be excluded from the disclosure exercise, and it would not greatly prejudice the fourth defendant's ability to defend the claim that the claimants have made against it. There are independent solicitors who are more than competent to advise, and indeed in many corporations, there will not be internal legal counsel who stand between the board of directors and the independent firm of solicitors engaged. So I reject each and every point made as to why Mr. Greeby should be involved in the disclosure exercise, and the same holds true for Mr. Astruc on an a fortiori basis. Having said that, the only question then is whether I should make the orders that are sought. As I say, without in any way suggesting that there has been wrongdoing on the part of Mr. Greeby or the second defendant, it should be made quite plain that they should not be involved in the terms of the orders that are being currently sought. And I'm prepared to make orders in those terms in order to ensure that there is no possibility of any misunderstanding, whilst making it quite plain that in my own view, they should not be involved in the disclosure exercise on a wider basis than is set out in the draft orders.
I'm grateful, my lord. We'll take that away and put together a draft order.
Well, it'll simply be in the terms of paragraphs 9 and 10, and no more.
Right, yeah, of course, my lord. Thank you for that. I'm not suggesting otherwise, but yes, you're right. They're just on the draft order. We will need to draft up some wording to cover the proposed audio searches that have been addressed and agreed, and also there's non-custodial keywords. So I think we will work up an order for those.
Yes, well, I want my earlier decisions, upon which I was addressed by Mr. Sampson and Mr. Conti, to be part of the order.
Yes.
And inevitably, my notes will not be as comprehensive as they might be, since I was giving extempore rulings. But I'm quite sure the transcript will show, and it should be easy enough to draw up orders. I am always dismayed as how long it takes before these matters come back to me with a draft order, by which time I have done I don't know how many other things and therefore forgotten what it is that took place, and usually do not wish to have to trawl through the transcript myself.
We've got it ready now.
My lord, if it helps, I mean, we've pretty much done the job of the first cut already, which we can share with the claimants today, I think.
Thank you.
Very good. Well, I'd be, I say it helps me enormously if the draft order can come back to me, and if there is any issue between the parties on it, and I wouldn't expect there to be any issue, particularly with senior counsel involved on both sides, who ought to be able to agree what it is that I've decided. But if there is a dispute, the sooner it comes back to me, the better, so I can resolve it.
Very good. So I think,
All right.
my lord, that's on our side. Happy to draw stumps. I appreciate that for the court. It's already late in Dubai, so I'm grateful for them as
Yes.
well, and to your lordship. So I think that's everything. Unless someone messages me otherwise, I think that's everything on our side, and we'll go away and draw up the orders.
Mr. Montague-Smith, is there anything that you need to raise?
Nothing further from me, thank you, my lord.
And there's no point in anybody putting any draft order in front of me at present. Better to do it in the round when it's complete and the parties are.
I think so, because I think the easy bits have been done. No disrespect to my own friends, because they've been very helpful, but the sort of easy bits are done, and I think the bit arising out of Mr. Sampson and Mr. Comte's discussion, they need to agree between the two of them and map out.
Yes, all right. You don't see any problem, Mr. Sampson, Mr. Conte, about agreeing what it is that I've ordered?
No, Your Honour. I mean, I've just come on camera because I'm not sure that we actually got to a clear endpoint on the audio recordings and what was specifically put in the order. I've just been checking the transcript and I can't find anything. So I was going to propose that we just address you 2 minutes on that in terms of what we put in the order, and just to check whether or not that's something that Your Honour is prepared to order, or whether that's agreed. I know Mr. Shivji said it was agreed, but having looked at the submissions, I'm not sure that we actually did come to a conclusion on that particular point.
This is yesterday's debate.
Yes.
Well, does someone want to tell me what they think I've decided?
Well, Your Honour, I think you thought they were plainly relevant, and so the question, it seems to me, is really just on the date ranges. And on our date range, I was proposing 1st of April to 8th of February 2015. We looked at some documents, and I think Your Honour took the view that it would be March rather than April.
There was a debate as to whether we'd go back to January, wasn't there?
No, yes, correct. It was the beginning of the year.
That was my learned friend's position.
I'd understood your lordship to have agreed to that, but that may be wishful thinking on my part. We can go back over the submissions if we like, but that was where I thought we came out.
Well, that's where I come out now, and I think that's where I came out yesterday.
Very good, Your Honour. Well, I think it's better to have clarity.
So it's a slightly wider range than you were asking for, Mr. Sampson.
I think it's better to have clarity over that, because I had
yes, absolutely,
that it was March.
Absolutely.
And then in relation to the 5th defendant's audio recordings, I think that the date that came out was that the time that the first Bank of Singapore relationship manager was employed was May. So I had understood that the search in relation to the 5th defendant's relationship managers would begin in May and run through to the 31st of December. But I'm not sure if that was actually agreed.
Yes, that was my lord. That was my understanding as well. So it was May. So it was limited in the way my learned friend had described. But the other two limitations were: firstly, the date range would be May 2014 to the end of the year 2014, and then secondly, the calls under 30 seconds would be excluded as well.
Agreed.
Yes,
agreed.
On both sides. I'm grateful.
All right, does that resolve any outstanding issues so far as parties are concerned?
Nothing further from me, Your Honour.
All right, very good. Mr. Sampson, I will do my best, should there be further matters on the keywords and so on that have to be resolved, to resolve them. I'm hopeful that you will be able to reach agreement on the details, as I've determined some high-level points. But if not, then probably it will either have to be an early morning hearing or something that I deal with on paper if it's going to be dealt with before Christmas at all.
I understand, Your Honour. I'm very grateful for that indication, but I hope that the parties will be able to agree.
Very good. All right. Well, many thanks to all and sundry, and thank you particularly the court staff who sat late for a second evening in a row. But at least we have reached one or two definite conclusions, if not everything. All right. Thank you. Do you think you could all sign out so I can have a quick word with the associate?